14.
With the force of approval and direction, the reproduction stands as to on the executive applications for Mr. DSJ, you are requested to appear in this case. This one. That encroachment cases. Encroachment cases. You were instructed to, you are requested rather, to provide protection, police protection, if at all they find inadequate. So that we have directed, please take.
Item number 2, WPC 9039 of 2024.
Applications shall stand. No plus.
Item number 3, WS 693 of 2025. Item number 4, WA 936 of 2025.
Perversity and illegality in the treatment of the other signature. The writ appeal stands dismissed with no order as to pass. Pending interrupt the application shall be put for.
Let's call the item number 5 as well, removal of defects.
Item number 5 for removal of defects.
Look,
I'm concerned with the fact that the thing is not maintained with actually removed.
no, is a removal of defects.
Madam, that is the defect. Madam. They have pointed out the actually not maintained with the what I have challenged is the judgment of the
Review was dismissed or allowed?
review at dismissed.
Whether the appeal lies? Tell me. I think under order 47, rule 5 or so.
There is no bar.
Yes?
There is no bar.
No bar. I'm giving you, sir. Order 47, rule 7, sir. Read. If it is allowed, appealable. If rejected, no appeal.
They are to come up with
What come up?
the urban thing with respect of this.
Can the judgment go beyond the spirit of the section? If the statute debars any appeal to be filed, can the judgment say the appeal would lie?
I am telling you the judgment only.
Sir, it is what is the jurisdiction which the court exercises? It exercises the review jurisdiction. If the review jurisdiction is exercised, then the appeal is not provided. Then,
but the appeal lies before the division.
sir, you are talking about the latest patent.
Well,
I understand, but I am again asking you.
This provision is also not applicable to read cases.
Mutatis mutandis applies.
No,
Mutatis mutandis applies.
not as it is. But it
As
is
it
also
is.
direct
Come ready, but
May
it is pointed out by the counsel appearing for the petitioner that
No, this is in defect. It is maintainability in issue, he will address.
Let us see.
10 days afternoon.
Yes.
No, I filed a IA in respect of this matter. Both our fee of.
Sir, when it is defective, unless the court says that it is in order, can we go?
In respect of this defect only, I have filed the IA matter.
Sir, the defect is not some procedural. The defect is striking at the root of the intertainability or the maintainability of the proceedings. Unless the court decides the maintainability, how can? If it is a dead letter, can you resurrect it?
Okay.
Come on Wednesday, satisfy us on that one.
10 days.
Yes, call the matter. No. All have come.
So item number 27.
Wait, please, Oman.
I decided to some small matters, fringe matters to
Yes, sir.
finish it off.
Metro, what time?
Now,
Yesterday,
Consider-
the agreement filed by the Ghanshyam Mehta. This 19 is 19-172-2025.
yes.
And one matter they filed a rejoinder with yesterday. And another matter
I
they
think
did
the
some
basic,
copy of this.
Mr. DSG, the basic question which we are now taking into account is the virus of a particular matter. I do not think that the pleadings, unless you disclose some very important documents which will definitely impact the points, then we will definitely, it's a pure legal question. And we will definitely consider all the matters on merit when provided.
Yes.
We hold the provision as intravirus, so there is no difficulty. But if it is ultravirus, then if the foundation is removed, then all the edifice or the castle cannot stand in.
There are many cases. Some cases division filed, it is pending. Since then, they are telling the ultravirus as well as demand notice of the state.
Whatever.
One
Let
part.
us see.
Second part, whatever pleadings they are required to be complete, they have not been completed. And
So
they
that
are
is
not
on merit.
served the copy to us.
That is on the merit of each case.
That's why I requested Lord Attorney General, he is agreed to appear. He is supposed to be appear also before my lord.
Yes,
He might
let
have-
him. I do not know whether he has already logged in.
This the associate told me that I was joining. I told him that he was
Let them
joined.
begin. Let us see if
That's why
necessary.
I'm
We'll
requesting
definitely give
any
you
date
time.
after 2 weeks and Jews cases are not been equalized each other.
Look at your other side of the.
In no manner, all these senior comes in.
All have come physically.
But still, then I have no options also. That's why I am playing match.
So let them start. Let us see that what they say. Let us see.
Wait, please, Your Lordship's first fixed the date today. At that time also, it was known
But the
they are not
difficulty is because they are saying that yesterday they have been handed over certain documents like a rejoinders or something that is what.
Highly planned, nothing, and no pleading otherwise.
Whatever, sir. If you intend to rely upon any new documents,
That can be.
that an opportunity to peruse, the opportunity to respond is inherent in the judicial system.
Now, in fact, it is ironic. My learned friend files a counter yesterday, and we are ready to go on. I'd like to argue right now and like to take some time to tell a lot of constitutionality. He files the counter in my case. My item is 27 to be taken up number 1, the writ petition number 31035 of 25, the first pattern.
Yes.
He filed the counter yesterday and we are prepared to go on. My husband he's not prepared to go on.
Yes.
And we are ready on the validity. We have worked on it, but we also are making submissions.
Yes.
So I am prepared to take some part of the day today.
Yes.
Explain that.
Yes.
Of course, subject to my lord's discretion.
Yes. No.
So may I start with that?
Yes.
Now let me do one thing. We have written submissions also in some detail. I will not hand it over now. Let me start first.
Or give me that the act and the rules.
If your lordship will note down the heads of my submissions on unconstitutionality in the opening 10 minutes synoptic view, purely synoptic, then I will elaborate each head. Your lordship will know the grounds I am going on.
When my lord, what I am praying, my learned senior may argue about the Tata Steel what number one matter. That is 31035. In that case, if by result they don't want to file any subsequent document, then go at this. But the next item is 16666 of 5/2021, Narway Power Limited. In that case, they have impressed or not serving copy to us. So we don't know what is that pass, what sort of ground they have taken. Or completely right. So they let them segregate them. We should not mix together all the cases.
It's obvious your lordship will not decide in segregated way. Let me do one thing then. My learned friend wants time. Your lordship, it's your lordship's handle. We have nothing to say on that. Your lordship can hear a synoptic account down, then decide to give him some time or not give him time. Either that way is possible. By one after that. So this is just a very quick thumbnail. Whereas my lord is concerned with the constitutionality or otherwise of 12A, Rule 12A, capital A,
Yes.
which has broadly two parts. There are other parts also, but 12 capital A 1 and 12 capital A 2. Our case is that the whole of it is unconstitutional, and for separate grounds, 12A1 is unconstitutional, and for additional separate grounds, 12A2 is unconstitutional.
Yes.
Now, the broad heads of my submissions are these ones. The first head is that 12A bracket 1A, I'm not going to the details, I'll give us the head on, introduces a concept of compulsory or notional dispatch, or rather compulsory notional dispatch. Namely, that as per a stipulation by the respondents, a mind lease holder must necessarily dispatch X in an annual period, minimum. And he cannot choose to dispatch, the word is dispatch, less than that.
Yes.
The principal statutory source of charging royalties and other charges is found in the sections, all of which talk only of removal. Namely, if I remove, which means if I take away from my mine 10 units, I have to pay royalty on 10. If I take away 20, I have to pay not only royalty but also district mineral fund, National Mineral Exploration Fund, etc. So all those charges. So the concept of levy, this is my first head only, first head. In the statute is only and only actual removal. The word actual is the operative word here. By a delegated legislation introduced later, which we say is unconstitutional, a concept of notional dispatch is introduced, namely, even if you do not actually remove, you have to pay royalty, DMAF fund, other funds, cesses, charges, on what notionally you should have removed, even though admittedly it is not removed. So that is a clear ultra vires, a mismatch between the parent section and the rule in question which your lordship is considering. The sections I will show in this connection with the first head will be inter alia 9, 9B, 9C, capital B, capital C. I will show you that. I'm not going to detail now. That's going to be how I show the ultra vires. And the short point is that a chargeability on actual removal by the section cannot be converted into a chargeability on notional, what you ought to remove, but you have not removed in fact, by a delegated legislation. That's the summary of the ultra vires argument. I don't know, Lord knows well, because it operates on a hierarchy of statute and rules. And the judgments will come, Malus. There are very many. Just one or two are very graphic. That this is, Malus, the first broadhead. The second broadhead, which I will elaborate, relates to, Malus, the second part of 12A. This is on the whole of the first article is the whole of 12A, and in particular 12A1 or 12A1A is called. 12 capital A bracket 1A. The second head of my submissions is on the second part called 12 capital A bracket 2.
Yes,
The-
more
this-
particularly the proviso.
Well, it's correct. Also the earlier part. Let me explain. It's a little more detail, even in the synoptic.
Earlier part says that what the previous minor
Yes.
he was extracting, you'll have to match.
Yes. Well. Yes. So 2A will be, Melis, the proviso, my lord, is right. But the nature, the main section,
Enabling provisions.
But let me just elaborate. So now we are the second head. It's a little more detailed, even in the synoptic version. Just give me 2 minutes. Now, this is wholly without prejudice to my preceding argument, which I just told. That it is unconstitutional. There is no remit in the section to permit dispatch on a notional basis to become and take the place of actual report. That's the first argument. Assuming I am wrong on that, that's why this is in the alternative. That there is some basis, which I totally deny, to stipulate a dispatch requirement, a notional dispatch requirement. Then this 12A2 in any case is bad. Why, Melis? Because 12A1A is self-professedly limited on this notional stipulation to year 1 and year 2. Whereas 12A bracket 2 gives an open-ended charter with no circumscribing and criteria and guidelines from year 3 to year 50. Lease is 50 years, so it can't get beyond 50 years. Now, why is this ultra vires clear? Unlike Wallace, without prejudice, alternative argument number 1. The reason is this. A minute's digression was this 2 years is found in the section itself. 12A came in to operationalize the intent of the section, which limited it for 2 years. That section in particular is known as 8 capital B. It also involves 4 capital B, but 8 capital B. I'll be coming to the details of 4B, 8B exactly. Now the section limits it to 2 years, clearly. The rule makes it open-ended to the life of the lease. Now there's another point here. Why these 2 years? That's a very important rationale. That requires a little digression. Well, what happened was that till 2015, my lord knows, we had, and I, in retrospect, believe that it was quite an odd kind of rule to have, possibly even foolish. First come, first serve. You have a queue. If I apply first, I get in first, subject to some disqualifying condition. So, your lordships had a general and rightful thinking across the country, and the modern system is give options to the best yielding person. So, have options. So, barring 1 or 2 special minerals, all were changed to a regime or proposed to be changed to a regime of auction. Now, for us, there were 300 odd leases in particular in the country, both captive and non-captive. Now, when you change a regime existing, they all fall for renewal in certain dates. You wanted to reset, you wanted to put a resync button, a reset button, to make all of them continue in future by auction. So, A, it involved resetting the termination of the existing leases. B, it involved auction for the continuance of the next 50 years. to have two reset buttons. In that category, of course, well, obviously they're all brownfield leases because they're in operation leases. Leases in operation, they have to be ended a few years after legislation, and they have to be restarted by auction, by everybody bidding in the auction. And then they'll continue whoever bids for 50 years. Now, this resync or reset button, which has to end them and then restart it, was a window of about less than 5 years. The Act came in 2015, and 2020 was the reset button for non-captive leases like us. We are concerned with non-captive. 2030 is a separate provision given for captive leases. Lots of me ignore that because at least me and some others here are mostly non-captive. So the fear came, and this is expressed, I'm giving Russia for 2 years. How you are using this compulsory dispatch stipulation totally contrary to the framers' intent for 50 years. The intent was that, look, we have 34 brownfield leases, namely leases already in operation. I will end it sometime in 2015, 16, 17, and then continue them till 2020 and press a reset button that all will auction in 2020. Now, in the auction, Malas, he's the old man. I'm the new chap. I bid in an auction, I win. So two provisions were made to prevent disruption of supply in the country. The main object was that in this transfer from the existing leaseholder who was expected to equally win as much as lose in the auction, he could lose, Malas. For a new chap who comes, one provision was that all the permissions he has will continue to endure to my benefit till 2020. Sorry, for 2 years after I win the auction. For 2 years. That's how 2 years came. Second was that this is necessary to ensure that I, the new successor, do not disrupt supply. Otherwise, the country will suffer with 334 leases. A new guy will say, look, I need time, I'm not ready, I need whatever, and I have decided not to supply. I will be producing, but I'll not produce for 2 years, I'll settle my system. So to force him to supply and to prevent disruption, and that's said so in the Travaux Preparatoires which precede this document. This window of 2 years was provided, that for 2 years you must have compulsory dispatch. That is something totally and radically different from what has become some kind of a revenue generating exercise endlessly for 50 years. The idea was not that you can stipulate plus 2 years requirement for 50 years of compulsory dispatch, because the 2 year requirement they knew was a temporary transient reset button window which was not in conformity with the Act, which Act only said 2 years. Then, Willis, this is why 12A2 in any cases completely without warrant from 8B and 4B, which stipulate 2 years. It is completely without basis from the intention of the framers, which I will be reading. And it is, Willis, misusing a power intended to have the word says, but the government says, seamless transfer. To convert that into an unintended revenue generating exercise, where for 50 years I will stipulate. That's head number 2. Head number 3, which I'll be troubling the lordships with, is, Willis, that, and this is very serious, this is partly what my Lord, the Honorable Chief Justice's bench heard me when I moved the interim order. Well, it's the linchpin of the entire mining law and the mining system. The foundational document is the mining plan. As the Lordship knows, it is the Bible, the Quran, the Gita for that. But there's nothing which is normally higher, because you cannot deviate from the mining plan at all. The mining plan has sanctity right from the beginning of the mining law. And there are any number of provisions, statutory, which give it sanctity. The regulator for the mining plan is the apex, a very respected and a very high-powered central government persona designata by name, IBM, Indian Bureau of Mines. They are an expert body. They are the last word on mining plan, etc. This is point 1. Point 2, the second facet before I come to my submission. The Act, the rules, and the practice invariably for 70 or whenever the Act came in till now, 57 till now, recognize the vital role of the linchpin foundational document called the mining plan through the IBM, which has to approve it. You cannot start mining without the mining plan, which in turn cannot be done, acted upon without the approval of IBM. The two other facets to be added here are that, as your lordship knows, this is mining law, is a very peculiar law. The list 1 is what controls it. Entry 54, as your lordship knows, so it's actually exclusive central government competence. But mining is one area where most of the work is delegated to the state, but under the central government authority. The state becomes the actual operator, collector, etc., etc. So the competence legally arises. Now, the IBM is one very stark exception where the Act keeps directly by persona designata name the power in the central government, acting through the IBM. Now, the IBM provides a mining plan. What is a mining plan? It's on record. It is the whole concept of intergenerational, ecologically sustainable exploitation of a natural resource, which in simple non-jargon terms means only this much. We all know the life of the mining plan is, the mine is 50 years. Now, it is possible that I can rapaciously exploit it in the first 2 years or the first 5 years. Because there is no restriction. Technically, I am working within the plan. I mean, within the boundaries of my mind. What is the problem if I completely exploit it? Or I can exploit it a little less rapaciously, but still over 10 years. The whole object of a mining plan is that ecologically, sustainably, safety-wise, and from long-term perspectives, the mining plan, namely the IBM, tells you that you can take only X number this year, only Y number this year, only Z number this year, and so on. Ultimately, it will be the same number. But the idea is that it is a phased out manner. Now, this third head is based on this one. There is a complete mismatch between a statutory expert regulator, the intent of the Act, the intent of IBM, and the compulsory dispatch requirement. Your lordship is the IBM here, and you say that you will do only 1 unit this year, 3 units next year, 5 units next year. The compulsory dispatch says you must send at least 10 units this year, minimum. And if you don't send, on the notional non-sending of what you should have sent, that's a separate point coming up on disproportionality. 5 charges are levied: royalty, DMEF, mineral exploration, performance guarantee, premium. I'll be coming to that separate. So, this is the third head of unconstitutionality. A superior statutory mandate creating an IBM, which in turn creates what I call a statutory document called the mining plan, which according to me clearly has primacy, is in fact nullified or heavily contradicted or diluted by the specification of minimum dispatch requirements, which is purely an executive order. And ultimately, at the highest, traces to Rule 12 only. So there is a contradiction. But suppose you say minimum every year you must take out 10 units. The safety, the phased out, the sustainability, the intergenerational equity requires that it should be 3, 5, 7, 8, like that. You are not the boss. You can't decide it. Under 12A, that too. Right or wrong, they decide it. And that's the practice. Well, there are several sections I have quoted in this regard. I have not about the primacy of it. Indeed, there are very, very strange, somewhat unsavory irony here. The irony is this, that the mining plan is made by a central government body and the All India apex, most well-known and eminent, they only consider scientists and experts in that body, IBA. And it works under central government overall. The law says, your lordship's common cause, I believe, directly says that the mining plan is supreme. Very strangely, very, very strangely, the central government affidavit with which we were blessed a few weeks ago in this case says the mining plan is subordinate to the contract between the parties. In affidavit, I'll be showing that. That is, of course, contrary to common sense, because a statutory document cannot be subordinate to a private contract between parties. But of all people, the custodian of that statutory document saying this is an affidavit is extremely unsavory, because they are looking at an individual case to live for that moment without realizing the implications of the state. And lastly, on this head, my third head, there is directly the same thing is shown in the letters exchanged between the parties. I write to them saying this is the phase-wise exploitation, correct, for safety, for ecological, etc. They say, no, make this change, that change. And then finally, they write that we approve this plan. That plan is completely at variance with what your lordship gets in terms of minimum dispatch requirement. That's follows by third head of unconstitutionality. I'm only saying about unconstitutionality. Various forms of ultra vires are unconstitutional. My fourth head is this. My fourth head is, these are obviously all in the alternative, taking textually 12A2 as it is. From year 3 to 50, you are going to be operating it by giving specifications of compulsory notional dispatch. But the government's own lament is that we can't operate this provision because there are no guidelines how to operate it for 50 years. The guidelines are there in the first 2 years. There are no guidelines for 50 years. I mean, year 3 to year 50. Now, the subheads are going to be. In the first 2 years, well, I'll not go into the minutiae, but there are like 80% of the preceding 2 years. That kind of a calculation system is given. I'll be showing that. For 12A2, no such specification is given. How do you calculate the minimum dispatch? What is your rationale and basis for calculating? And this is the bulk. This is the body and the head and the entire body, the previous first 2 years and the tail ones. There is no guideline for the body and the head.
Yes.
The other facet of this is that this will hit directly Article 14 in being arbitrary without guideline how to operate. Because I can't sit in my office and just say, you dispatch 10, next year 15. There are no guidelines. How calculate 10? How 15? So Article 14 is clearly, I will be taking a small digression about the trajectory of Article 14, which your lordship has seen a very, very, very proud moment for Indian constitutional law. From starting with anti-discrimination weapon only, your lordship's old judgment, Dalmia and Charanjit Chaudhary. Stage 2 was the seminal landmark of Royappa, where for the first time Justice Bhagwati brought in arbitrariness or anti-arbitrariness as a concept. Didn't develop it fully, but brought it in. As a side comment, because Justice Bhagwati laid down very well frontal law, but the petitioner who helped to lay down the law lost, as he did in Ramana Shetty also. Then whether this anti-arbitrariness concept was developed in these 3 or 4 seminal cases, Ajay Hasya, Ramana Shetty, Maneka Gandhi. But till Maneka Gandhi and afterwards, we kept on insisting as a fiction, law functions and fiction, that we are doing only procedural due process in 14. We never went beyond, because the due process was a dangerous word. So we said procedural due process.
That was argued at the Constituent Assembly also.
So, to pay lip service to Mr. B.N. Rao, who met with Justice Frankfurter, and Justice Frankfurter said, whatever else you do, please delete this due process of law phrase in your draft constitution. Which is why, for whatever reason, Mr. B.N. Rao ultimately picked up the Japanese constitution and put Article 21, except in accordance with law.
Established procedure of law.
So that due process
that was debated upon. There was the the discussions during the Constituent Assembly debate.
Yes.
You will find that at least 5 or 6 of them, they propagated strongly that the due process of law should be ingrained into the articles. Otherwise, it will be a meaningless. That was ruled out. It says that.
This is why Mr. B.N. Rao had a dilemma. He actually wanted to, but then he somehow came back and reported that the home and the origin of due process people are actually delegating it. Justice Frankfurter were delegating for a different reason. He had written a series of judgments which were against applying due process to economic legislation. So he anyway, that's a different history. Net result is that we in India, because of that debate which my lord is mentioning, kept paying lip service to due process. So Article 14 has gone from anti-discrimination to Royappa to Maneka due process, but only procedural, no substantive. Then comes the final seminal stage where we now have full due process. We have manifest arbitrary and theology of cases, adultery, that Shaira Banu, that others, Swiss ribbons, all of them. Justice Nariman has authored many of them. Clearly now, You can have any fiction of language, but you have full-blooded due process. So Article 14 has always traveled remarkably. Now today we don't need all that Article 14 for this. What I am arguing. Article 14 today will apply squarely because you have a power endlessly for 50 years or 48 years to give these things without any guiding principle. It's completely arbitrary, vague, etc. And well, that is the fourth head which I was talking about. Then in fact, in this fourth head, there are two letters of the government. It's very pitiful. Government to government, saying you have given us this requirement to give compulsory dispatch. We can't operate it. It's vague. What are the guidelines on how we stipulate? Government accepts it. I've attached that. I quoted them. It's on the record. Government says we cannot operate it because there is no guidelines. It's vague. It's imprecise, and we don't know how to stipulate minimum dispatch. They are now talking only of year 3 to 50, which is the real issue. First 2 years, many cases have passed anyway. Then, most important aspect in this head itself, fourth head, of applying manifest arbitrariness as now adopted by Article 14 and just unanimous judgments, is that was compulsory dispatch for 48 years. This is all part of 14. Because I have to bring my factual situation argument into a head of law on constitution. But let's just consider what it actually does on the ground. We tend to be abstract of Article 14 and RAPA and Maneka. The real story is this. Well, you are stipulating compulsory dispatch for 48 long years. First point, it creates huge irreversible distortions in the market. So I must dispatch, irrespective of a buyer, irrespective of a correct price, assume there is a buyer, irrespective of need to dispatch. Therefore, you make a buyer's market. And the seller of the mine, at the risk of bankruptcy, must still, prices have fallen, market is not conducive. I can't hold it to the next year. If I don't dispatch this year, I pay 5 charges on the non-dispatch. So this is what Article 14 states in the face. This is creating an artificial market without any regard to individual volition. Another facet of Article 15 is the entire price equilibrium, the ecosystem of a buyers and sellers collectively negotiating and coming to a price. The doctrine of necessity to buy and necessity to sell. All is completely without law. Whereas your lordships, if your lordship passed a legislation, would have difficulty in sustaining it. Here you are doing it by executive order. Then, the stipulation is a mechanical manner. It doesn't say that we are doing it because the whole allegation in this is that there are no guidelines. And, of course, the earlier issue I said already. It is a very abstract, ad hoc superimposition externally, which has no nexus to the ecological sustainability of the mine itself over the years. So this is my fourth head. My fifth head is the doctrine of disproportionality. Well, apart from the 4 expansions of Article 14, which I have just summarized, there are significant additions of other doctrines under the rubric of Article 14, which was not there earlier. My Lord has developed a series of judgments on disproportionality, which is another facet of Article 14. Just like my Lord has elevated natural justice violation also to Article 14. But here concerned with disproportionality, it's a clear case of a separate facet of 14, disproportionate, my fifth head. Why disproportionate? Your Lordship will, of course, see the law on disproportionality, balancing test, necessity test, etc., etc. Justice Sinha has a series of judgments on this, but the Lordship will know. But what is the application of that to this case on the fifth head? Is it not completely different? We are not talking of crores, hundreds of crores of rupees. I've given an actual example where the figure is 1,902 crores for 1 year. That it is completely disproportionate in that from year 3 to year 48, year 50, 48 years. By stipulating a minimum dispatch, you are forcing a man Now he doesn't dispatch. If he dispatches, the matter ends. He suffers. He doesn't go to court. If he doesn't dispatch, 4 or 5 very strange things happen. So I find that the market can sustain 100, I sell 100, but the stipulation is 150. So I've dispatched 50 less. Now 50 less first leads to 50, the quantum, multiplied by the royalty rate. In my actual example, that is 15% of the royalty rate, not the full rate. It will be 15% of the royalty rate. In my example for the year 23-24, which I have given, that figure comes to 212 crores. 15% for not actually dispatching, for what I ought to dispatch. Then on this, 10% is charged as a second charge called the DMM. Then third, on this, 2% of the deficit is further charged on a third charge called NMET, National Mineral Exploration. We have no problem. We are paying on the main actual dispatch anyway. Actually, everybody is paying. We are now talking of paying on the non-dispatch. Then fourth charge is a bid premium. So this all adds up to my figure. Fourth charge is a bid premium you have to pay for what you have not dispatched. And fifth charge is a performance security. In my written submissions at page 29, you also will find the most startling figure of these 5 additions with the basic charge coming to 1902, just under 22,000 crores. 2,000 crores in 1 year for 2024 for non-dispatch. Or not for actual dispatch. Nobody is disputing. Well, nobody is saying that I dispatched 10 and I hid the money. I kept the money back. This is completely disproportionate. What else is Article 14? This is completely illegal. And there is one more but absurd consequence, which is a separate consequence, a sixth consequence of double payment. Now, Lordship have noted that 150 is the stipulation. I only dispatched 100. So 50 is in deficit. I am paying all these 5 charges and I paid them. Now, what happens? I have to dispatch the next year. Naturally, like money.
Oh, I understand. You wanted to say that for this 50, since I have already paid whatever is supposed to be paid at the time of dispatch. Now, at the time of actual dispatch, I have to pay more. So it's the double taxation that is attractive.
These are all payable before it moves from this boundary of my factory or wherever my mine is to the 1 feet outside. They're all payable in advance. And your worship doesn't give me a pass. Your worship doesn't allow me to move. So it's not that there's an option that, oh, I will calculate at the end and I'll fight with you and say, no, this is wrong. This is with greatest respect constitutionally absurd. And all this is happening under 12A, not a statute. But according to me, I dare say if there was a statute, I would be able to say it's unconstitutional. I don't say about a constitutional amendment. But this is being done by a rule. It's the lowest form of delegated legislation as far as this hierarchy is concerned. An actual stipulation is done by an executive order. The rule is some kind of a general thing. The actual thing is by an executive order which says this year's stipulation is 10, next year's stipulation is 20, etc. Then, the last constitutionality ground, there are other grounds, but only a constitutional last ground, the 6th head, is again in Article 14. So there are 3 of these 6 are Article 14. One is vague, uncanalized, one is disproportionate. And this third head is creating 2 artificial classes. There's another interesting passage which the government forgot about. They made this rule without thinking of Article 14. It's treating equals unequally, which is what your Lordship knows is prohibited. Unless there's a very special classification, then you have to show the nexus it bears to the object which sought to be achieved.
Intelligible difference here has to be.
It's very simple. It's a very simple point. This is my last head of the 6th head of constitution. Now, this is applying, entire last half an hour I have argued, applies only to what I may call for ease of convenience, brownfield lessees. Because obviously, the auction reset button, where you thought you will prevent disruption of supply for 334 lessees from transferring from Mr. Mishra to Mr. Singh, to make this transfer seamless, you provided a 2-year window or now a 48-year window. No problem either. But this is all brownfield. Mr. Mishra was the pre-existing, Mr. Singhvi continues the pre-existing. There is no greenfield here, but none of this applies to a chap who's sitting next to me and bidding at the same time for a new lease. We are all bidding together. But he also bids for a lease. He also gets a lease. But because it's greenfield, there is no legacy, there is no history. Therefore, there is no 2 years. I would rather not to no 3 years to 48 years. So there is no compulsory dispatch. So the greenfield class has no compulsory dispatch oppressive requirement for 50 years. So at the same option, theoretically, Mr. Mishra bids and I bid. He gets a new lease, he has no requirement. Because I have inherited a lease from somebody, I have a requirement. This is an Article 14 class creation with no, it may have an object to be served for 2 years, but a seamless transfer. There can be no question of any object for 50 years. These are the heads. Apart from the constitutional heads, there are 2 other grounds. I just take 3-4 minutes more on the disruptive part, then I'll go back whatever you should decide about this matter, how to go about it. One is the general principle which I made submission for, I lost in the first hearing, which is not, I've done with constitutional 6 now. Now I'm on the 4 other very significant grounds of unreasonableness and requiring this stoppage of this kind of a regime. One is a clear compulsion to violate the law. Asking me by a direction on pain of penalty to violate an existing law. Because on the left hand says, please dispatch 20 units. The right hand IBM plan says, produce only 10 units. Produce. Now, the answer, they will say one is produce, one is dispatch. You can't dispatch without production only. You're not supposed to be starting from a state that you have got some storage of last 50 years and you dispatch from there. The concept goes hand in hand. There is no question of dispatch compulsorily 10. But the mining plan says produce only 5 because of ecological, safety, intergenerational equity, phase down, whatever. That's not my job. That's not even their job. One of the states, it's the job of the IBM. So this is a direction to violate the law. Clearly, the mining plan is the law. 5 safety. B, related to that, it is to do the impossible. What is the person to do between the devil and the deep sea? It's a direction, it's a legally mandated direction by 12A to do an impossibility if one wants to be law abiding. Then the other thing is, it is also a very strange case. Actually, I do not want to suggest to your lordship that we are escaping the larger issue. The shortest issue on which at least my 2 cases, item 1 and item 5, can be disposed of, is the extraordinary and simplest issue, literally a 2-sentence issue of natural justice. But I don't want your lordship to dispose it on that. I'd like your lordship to decide constitution. The 2-sentence issue is, my learned friend starts with a demand notice of 7th of January 2025 to me. They say, you, Mr. Singhvi, please pay for year 4 or year 5, as the case may be, non-dispatch, notional dispatch, so much rupees. I write back saying broadly what I've argued for the last half an hour before my lunch. I write that back in 28th of January, the same month, within 2 weeks. This is January 25. There is complete and utter silence. They don't call me for hearing, which I asked for. They don't adjudicate. They don't do any quasi-judicial process. They don't do anything by way of a decision on my reply. The impugned order comes straight after 6 months. First time, nothing in between. 3rd July 2025. Without a hearing. Without calling me. And in between, not having the process of a process first. No adjudicatory process. I'm not talking about judgment, I'm talking about quasi-judicial, something. We are talking of 2,000 crore demand. So this by itself is sufficient to set aside the impugned order. Then there are some other grounds which I can. Broadly, these are the heads. So I can take them one by one and start if you also want like that. Let's start with the legislative history of 12 years.
Analyty when you talk about, because there is a mismatch between the productions and the dispatch. You say that the mining leases or mining plant is I would say the sacrosanct document in the sense that one cannot ignore it or make any deviations therefrom.
What's it?
Now they have said that the mining the plan or something is something which is subordinate to and not the supreme, as you said, is a sacrosanct document which laid the real foundations of applying any provisions of the law before it comes. Now, what it says, the mining plans, it says that it talks about a minimum production or it talks about a rigid quantity of productions
Maximum.
or a maximum. I was just coming into that. The word maximum it is used.
It is stipulated. The whole idea is.
No, understand.
He's not saying that you can't produce lesser. The idea is you can't overexploit.
No, that we understand. There are multiple factors which really played into this regard. Sustainability, balance, ecological balance. Then also
I can have one view. I can have another view. He can have a third view. It's very clear from the statute that this view is only there of the IBM and scientific experts. I mean, we may think something else about the mine.
that we will definitely, after hearing them, we will definitely take into account whether this IBM is.
Yes.
Is a body which really controls the entire affairs so far as the mining is concerned.
For mining.
And there cannot, yes, mining plan, and there cannot be any deviation. That we will consider it. We were just trying to understand this aspect. So it's a maximum. It is not a minimum or a definite quantity. It's nothing. Yes.
Now, if you're also to start on the main thing, I have a written submission. It seems long with quotes, things for convenience. Otherwise,
The bullet points.
No, it quotes.
Okay.
It won't take. So, your Lordship may start this process by seeing the legislative history of 12 years. Then we'll come to the 6 submissions. This is the same sequence I just given.
True.
Same.
Do you have that particular bill when it was introduced?
Everything. It's all quoted. That's why it's long, because it actually quotes it there to.
Because the object and the purpose underline this incorporation has to be understood.
So we might spend 30 seconds on the index. Let's come to the index. Let's come to the index. Index first. This is the summary which I have given you, Lordship, at page 1. Now, legislative history is what I have given you to 4. And then each item which I have just said, A to F, are 6 heads of unconstitutional. Only unconstitutional. The actual pages are given with the quotations. Then verse 4 is the question my Lord asked us, Big Roman 4. Mining plan override the provision of the NDPA, compelling the petitioner to produce an excess of the limit prescribed under mining plan completely illegal. And then the last is on the non-constitutional grounds, which is what is breach of natural justice, the main one, 32 to 34. That's the scheme. If my Lord will now come to the legislative history, which is important. And then the submission starts straight after. Come to page 2, Malas. After introduction of the auction regime in MMDR, a transition sunset period was provided for all brownfield leases, namely existing and operational ones, as opposed to virgin greenfield ones. Just I'll be showing the section, just tick 8A5, where they said non-captive leases are extended till 2020. This regime came only in 2015, January 2015. This regime, otherwise, Lordship didn't have anything to do with auction. So they said the sunset period was 5 years. That is ending, we are considering non-captive. Otherwise, for captive, it was 2030. Let us not go into that. The present lease, my case was Sukhinda, within the category of non-captive. That is expiring in March 2020. Owing to the impending expiry of such non-captive mining leases, the President of India promulgated the Ordinance of 2020, which was eventually replaced with the Act, with effect from 13th March. The amending Act introduced the following crucial amendments. 1. Conditions for efficiency in production. Notwithstanding anything contained in 4 capital A, the central government may, in the interest of maintaining sustained objectives, sustained production, very clear from the language, prescribe such conditions as may be necessary for commencement and continuation of production by the holders of mining land who have acquired rights, approvals, clearances, and the like under the 8 Ps. So the idea is, whether the sudden transition, you don't stop. The country will not have enough minerals. Read 8B, which made it very clear. Provisions for transfer of statutory clearances. This is transfer from the existing to me, I am in the auction. The provision of this section should apply to minerals other than the minerals specified, notwithstanding anything contained in this Act or any other law for the time being enforced. The successful bidder of mining leases expiring under the provisions of subsections 5 and 6 of 8A and selected through auction as per the procedure provided under this Act and the rules shall, this is the operative clause, shall be deemed to have acquired all valid rights, approvals, clearances, licenses, and the like vested with the previous lessee for a period of 2 years. Provided that subject next page to such conditions as may be prescribed, such new lessees shall apply and obtain all necessary rights, approvals, clearances, licenses, and the like within a period of 2 years from the date of grant of the new lease. Notwithstanding anything contained in any other law for the time being enforced, it shall be lawful for the new lessee to continue mining operations on the land in which mining operations were being carried out by the previous lessee for a period of 2 years. Clearly, the sunset clause or the transitional clause is 2 years intended to be. Then just one more section here, was 13(2)AA. This is the rule-making power.
Yes.
And the AA says, may make rules for the following matters, namely, the conditions that may be necessary for the commencement and continuation of production by the holder of mining leases under 4B. So even assuming you had some power, it was intended clearly to be for 2 years. It is relevant to advert to the statement of objects, question my lord asked, which I had said in my opening. The mining leases in respect of 334 mines of iron ore, manganese ore, and chromite ore are expiring on 31st of March, out of which 46 are working non-captive mines. Most were captive, some are non-captive. I'm sorry, most were non-working, these are working. It has been observed that some of the states have initiated action to auction these blocks. However, the mines allocated through auction can start mining operations only after obtaining as many as 20 clearances. Very clear what they intend. Because you are transferring, new auction is happening. This process is causing inordinate delay in commencing of mining operations and subsequent production of minerals. Further, during the allocation of coal blocks under the Mines and Minerals Act and the Coal Mines Act, certain difficulties have arisen which need to be addressed immediately. To overcome the aforesaid difficulties in mining sector, it has become necessary to make certain amendments in the MM Act and the Coal Mines Act so as to facilitate, mark this, seamless transfer of all valid rights, approvals, clearances, licenses, and the like for a period of 2 years to a new lessee in case of minerals other than coal. We are not concerned with lignite and other atomic research. 2.5. In terms of the aforesaid provisions, the central government took the following delegated legislative actions. On March 2020, 12A. So now 12A is coterminous with the sections. The previous para is the sections. This is coming in there. On 21, now let's kindly note, 21, 12A and 12A1 are further amended. At first blush, it is noteworthy that 12A in its entirety purports to impose an obligation of compulsory dispatch. This is contrary to each of the provisions of the Parent Act 4B, 8B, and which use the expression production. Ex fascia, there is incongruous. This is the legislative history only. Now, note one thing, it will be coming later. In 2021, from the section which I read, was 8B, 2 years is deleted. Familiar. But the rule is not changed. And the rule came in when it was 2 years. So you cannot say that the intent is then without an affirmative statutory mandate to create a charter for 48 years future. But some of these come later. Now let's go one by one to the constitutionality. Now this is the first contention which I have summarized 6A, page 4, big Roman 3A. This is my first head of unconstitutionality. The issue of notional compulsory dispatch is entirely brought out by 12A1, whereas all the sections containing the source of the power limit themselves to actual removal. That is, whereas removal is the same as dispatch, but actual, not notional. That is 9, 9B, 9C. Consequently, in providing for a stipulation of compulsory removal dispatch, the same is ultra vires, so and so, so on. Rule 12A imposes an obligation of notional compulsory dispatch removal in the event the lessee does not meet a particular target of dispatch. Removal of mineral in a year, the executive would impose prejudicial civil consequences. First, royalty, second, DML, third, NMET, fourth, bid premium, etc. They also performance guarantee. Now just leave this note and start those sections. You can see it from the book rather than see it from the book. They're all here. They're all reproduced. But we will see from the book. 9, please start with 9. So this is the overarching argument of ultra vires. The concept is removal actual versus notional. This is the larger argument. The second argument is the narrower argument. Royalties in respect of mining leases. The holder of a mining lease granted before the commencement of this act shall, notwithstanding anything contained in the instrument of lease or any law in force as such commencement, pay royalty in respect of any mineral removed or consumed by him or by his agent, manager, employer, etc. from the leased area after such commencement at the rate for the time being specified. It is quite simply understandable because I produce 10 units, I consume it also. Maybe I'm not removing it, I consume it.
So it is also applicable to a particular mining lease which was granted before the commencement of this.
Exactly. Necessarily. The law doesn't change on these fundamentals just because it's the previous or the subsequent. See 2 now. The subsection 2. The holder of a mining lease granted on or after the commencement shall pay royalty in respect of any mineral, again, removed or consumed by him, same thing with the agent, manager, employee, from the leased area at the rate for the time being specified in the second schedule. I don't think 2A and 3 are relevant. I can be 9 capital B now, which is after 9 capital A, dead rent, then 9 capital B. Not. Incidentally, this one small digression. 9A is interesting from the point of view that suppose somebody, that's a very experienced, that's not the case here, Roshan is concerning. He's a squatter. The correct word is squatter. So I hog and squat on mining leases. So I don't operate them at all. So I get a mining lease and I just squat on them and do nothing. So it's a non-operational one. That is dead rent paid. That is 9A. That is not the category for which this 2-year and this calculation is being done. Now come to DMF. In any district affected by mining related operations, the state government shall by notification establish a trust as a body to be called DMF. We are proud to contribute to the nation in that whatever we remove, each one of us pays DMF. And there is no cavil that I have to pay or don't have to pay or no dispute on that. We are saying on what I don't remove, I have to pay also now. That's my problem. Now come straight to 5 to save time. The holder of a mining lease, I'm subsection 5.
Yes.
Or a composite license granted on or after the date of commencement of the MMDR, that is the new one, the amendment. Other than those covered under the provision of subsection 2 of section 10A, they're not concerned, shall in addition to the royalty, mark the word in addition, pay to the DMF of the district in which the mining operations are carried on, an amount which is equivalent to such percentage of the royalty paid in terms of the second schedule, not exceeding 1/3 of such royalty at 50%. So my removal is 10 units. Royalty, I believe, is 15% of 10 units. 15% of 10 units.
So 1/3 of,
And 1/3 of that 15%.
it is the maximum.
Maximum. It is 10%. They will
It may be less.
Less.
There is no difficulty.
Because these are one of the nature of cesses for specific
Yes.
object. Considering is not the same as it. Now, Willis, 9 capital C is another such charge for exploration. They've been earlier had their litigations, etc., but now they are established. This is 2%. The central government shall by notification establish a trust as a non-profit autonomous body to be called the National Mineral Exploration Trust. Subsection 4 alone will be necessary. The holder of a mining lease or a composite license shall pay to the trust a sum equivalent to 2% of the royalty paid in terms of the second schedule in such manner as may be prescribed by the central government. So now we have another third charge of 2%.
Yes.
Now, Willis, my point here, if you should come back to page 5 of my submission, is the larger basic starting, this is my first head, starting point of a direct Willis mismatch. That, sorry, I have to show 12 levels, my apologies. I've only shown the section, I haven't shown 12 levels. Obviously, that's the ultra virus provision.
Yes.
So, 12A. Now, 12A, my lord has marked that word removed or consumed. Now, just mark the contradistinction word 12 capital A, 1. I might as well read it a little bit in length because this is the main provision and I won't come back to it. Notwithstanding, additional conditions for commencement and continuation. So it's additional conditions. Notwithstanding anything contained in these rules, during the first 2 years from the date of execution of new lease, the holder of mining lease to whom the order of vesting of rights, approvals, clearances, licenses, and the like have been issued under 8 capital B, not the word 8 capital B, shall maintain such level of production so as to ensure minimum dispatch of 80% of the average of the annual production of the immediately 2 preceding years on pro rata basis, failing which appropriate action in accordance with the MDPA shall be initiated. This is what they call the contract. MDPA, the contract. Now note it, just pause here. Just pause for 5 seconds. 1, it is clearly cognizant of 8 years. 8 weeks. And clearly mentioning 2 years. Secondly, it talks of ensure minimum dispatch of 80%. Does it also find anything on minimum dispatch in the section? My question to myself. Obviously not. So in an ultra virus manner, they smuggle in the concept of minimum dispatch. Third is the detailing in 12A, which is going to be conspicuous by its absence in the next subclause. 80% of the average of annual in the 2 preceding years on a pro rata basis. So 3 facets will also be noted here. There is detailing limited to 2 years, 8B is mentioned, but most importantly, minimum dispatch. I'm on my first argument, not my second argument. I'm covering the rule for both the arguments. Just for
Yes.
the extreme. So clearly, Millers, minimum dispatch is an ultra virus addition or introduction. 1A, in case of shortfall in dispatch from the minimum dispatch required under 1. Now, 12A2 itself limits it to 1, or at least links it to 1, which shall be assessed on a quarterly basis. The lessee shall, in addition to the amounts payable under Rule 13, for the actual dispatch. So they recognize the mismatch ones. Actual dispatch. Also pay to the state government an amount equal to the difference between the following, namely, the amounts payable under Rule 13 of the auction rules for the quantity equal to the minimum dispatch required in the said quarter on the basis of weighted average of grade of minerals dispatched during the quarter. The amounts paid under Rule 13 of the auction rules for the quantity actually dispatched the same. I'll just pause here because I'm going slow. This is straight away putting for the actual quarter. There is no system of calculating for the preceding 2 years of past. This is saying you dispatch and you pay. There is no limitation of 2 years, which is why it's being applied for year 3, 4, 5 till 50. It's common ground. All the petitioners here have this application for all the years up to 50. I'll be reading Rule 13 in a minute. Let me finish reading this. Can I come to Rule?
Yes. I understood. Yes.
Provided that a reconciliation of the amounts paid under Rule 13 of the auction rules shall be done at the end of the year. And on such reconciliation, if it is found the lessee has dispatched more than or equal to the minimum dispatch required under one for that year as a whole, then any amount paid by the lessee for the shortfall in dispatch in any quarter of that year shall be adjusted with the amount to be paid for the last quarter of that year. This is an adjustment rule. You find that you overpaid, underpaid. Provided further that the amount of performance security for non-compliance, etc. I can come to two novels just to finish this. Subclause 2. 1C, no. Well, may I read 1C also? The new lessee shall ensure that the annual production beyond 2 years from the date of execution of new lease, beyond 2 years is here, is equal to. I'm reading 1C. I'm sorry. You're also reading 1C.
No, I'm reading 2. There is no difficulty.
The new lessee shall ensure that the annual production between 2 years from the date of execution of new lease is equal to or more than the annual production by the previous lessee, and shall subsequently work out and implement an annual production plan to ensure that the mineral resources are fully exploited during the period of the lease, failing which appropriate actions. This is completely vague. It's very difficult.
No, what it says is that so far as the first 2 years are concerned, there is another modalities which is provided. This the sub-rule 2 talks about what would happen after these 2 years. And then say that we can definitely adopt some kind of a modalities, how to work it out. So this is what it says, and then says that if you don't do it, then consequences would follow.
There's no 3 facets in the summary itself. Straight away. Facet 1 shall subsequently work out and implement.
True.
There can be nothing more for crores of rupees, hundreds of crores. There can be nothing more delightfully vague. And subsequently work out means, fellas, the chancellor's foot and the chancellor is him, not me. Neither I am the chancellor nor I am the foot. I have no say in it, but subsequently work out what? Your lordship knows the reality. They will stipulate from a farman from the mountain. Number two, to ensure that the mineral resources are fully exploited, there is some clear illusion of grandeur. This is what Mr. IBM is doing, sir. This is not what the mining development agreement does. The primary organ, the agreement can never say that the mining plan says 100 units in this year and 200 next year. But by agreement, you shall produce not as per 100 and 200. So this is an illusion of grandeur by the draftsmen here as far as they are concerned. This power in the last sentence of 2 rests with the IBM. Provided that the new lessee shall also ensure that at least 80% is dispatched.
Same thing is borrowed from there.
But what is the criteria? What is the system? There is preceding 2 years, average this, that. Here it is to work out. So, 2 is a class by itself. This 12A 2 is a separate class. Now, this is, I just wanted to give the textual thing. We will not see it. So, we come back to my first argument. Just come to page 5. We'll end of my note. The first argument is a vanilla argument of ultraviolet. Please put the rule 12A1 in particular here, or 12A12 for that matter, the whole of the 12A, and put the section here. There is removal, there is dispatch. There is consumption, there is dispatch. It's a smuggling in an ultra virus condition. That is the solution. Let's come to page 5 of my note. It is axiomatic the delegated paragraph A.3. Axiomatic the delegated legislation of any kind and rule 12A is admittedly delegated legislation cannot alter the fundamentals or conceptual underpinnings of the main section. By no stretch of imagination can it be said that this is the heart of the matter, conscious or voluntary non-dispatch, non-removal by the lessee has been prohibited, penalized or rendered punishable under the main section. Well, you're penalizing it. In stark contrast, 12A1 imposes severe adverse civil consequences for voluntary non-dispatch. Even though expressly, none of the statutory sections provide for any compulsory dispatch removal or adverse civil consequences for voluntary non-dispatch. Nowhere. You can't point out a single one. It is well settled on subordinate legislation which cannot create substantive rights obligation. This is a separate facet. Subordinate legislation can't even create substantive rights. And Kunj Bihari cited. I have two things. I have a comparison of all those persons. But what I have done there also production is to make a law digest, which is just quoting the relevant paras in a separate digest, which is a separate volume. Both of it will be given to the Lordship. Not now, but the Lordship may just keep it as a side. 8.7, this is a separate part of ultra virus. The first part is can't create substantive rights.
True.
Second part is travels beyond the contours and boundaries of the main section. There again, Indian Express is well known. But I have now settled only one case for this, 8.8, to save time. Let's see 8.8. Naresh Chandravalas puts it well. Because more recent ones. From the reference to the precedent discussed above and taking an overall view, we proceed to distill and summarize the following legal principles that may be relevant in adjudicating cases. Read ultra virus. The doctrine of ultra virus envisages that a rule-making body must function within the purview of the
Making authority.
rule-making authority conferred on it by the parent act. As the body making rules or regulations has no inherent power of its own to make rules, but derives such power only from the statute, it must necessarily function within the purview of the statute. Delegated legislation should not travel beyond the purview. Travel beyond is my complaint. Then ultra virus may arise in several ways. There may be simple excess of power over what is conferred by the parent act. Delegated legislation may be inconsistent with the provision of the parent act. There may be non-compliance with the procedural requirement as laid down. It is a function of the courts to keep all authorities within the confines of the law. If a rule is challenged as being ultra virus on the ground that it exceeds the power conferred by the parent act, the court must firstly determine and consider the source of the power, which is relatable to the rule. Secondly, it must determine the meaning of the subordinate legislation itself. And finally, it must decide whether the subordinate legislation is consistent with and within the scope of the power delegated. Delegated rulemaking power and statutes generally follow the standardized pattern. A broad section grants authority with phrases like to carry out the provision, carry out. I'll skip that one. I'll skip that. Come to 37.7. However, it must be remembered that such power delegated by an enactment does not enable the authority by rules and regulations to extend the scope or general operation of the enactment, but is strictly ancillary. It will authorize the provision of subsidiary means of carrying into effect what is enacted in the statute itself, and will cover what is incidental to the execution of its specific provision. In that sense, the general power cannot be so excised as substantive rights or obligations or disabilities. So it covers both purposes, travel beyond and create substantive rights. Two facets of ultra virus. 8.9. 12A, however, is not the case of the provision of MTR. Look at that first. I'll come to my second head now, page 8. So this is the first broad head of challenge on ultra virus. Now we come to 12A2, which is a little more detailed. Rule 12A2, providing for minimum dispatch for the third year to the 50th year, is expressly ultra-vires 4B and 8B, each of which limit themselves to 2 years. Each of the submissions are B.2. Also, should be skipped. Come to the section straight away. The section 4B. Conditions for efficient production. Notwithstanding anything contained in 4A, the central government may, in the interest of maintaining sustained production of minerals in the country, prescribe such conditions as may be necessary for the commencement and continuation. Dead rent is one. There may be one or some other situations. Or a 2-year hiatus of a sunset clause by the holder of the mining lease or acquired rights approvals clearance. 8B. Now, this is how it came in first place. 8B. It was changed later on, it was deleted. The period. The provisions of this section shall apply to minerals other than the minerals specified in A and B, notwithstanding anything contained in this Act or any other law for the time being in force. The successful bidder of the mining leases expiring under the provisions of subsection 5 and 6 of 8A and selected through auction as per the procedure provided under this Act and the rules made thereunder, shall be deemed to have acquired all valid rights, approvals, clearances, licenses, and the like, vested with the previous lessee for a period of 2 years. Provided that subject to such conditions may be prescribed, the new lessee shall apply and obtain all necessary rights, approvals, clearances, licenses within a period of 2 years from the date of grant of the new lease. Notwithstanding anything contained in any other law for the time being in force, it shall be lawful for the new lessee to continue mining operations on the land, in which mining operations were being carried out by the previous lessee for a period of 2 years from the date of commencement of the new lease. So we are giving you a window, a sunset clause, a transitional court to set your house in order. It is not supposed to give you a power to collect money.
What we can reasonably gather from the bare reading of this particular provision is
What to do?
that this transition phase of 2 years, which you are really putting much emphasis thereupon, that it is restricted to these 2 years. So far as the I think the procurement or getting the new license and necessary rights, all the permissions,
Permission is one.
because it will take some time to do it. He may be allowed to continue under the existing, that's the previous lessee's,
20 are required.
right, and then continue mining just to ensure the seamless production and also the removal. I'm
That's
consciously using the word removal, not a specified quantity or something.
So that's
A removal.
First part is continue with the permission. Second
True.
is seamless.
So according to this, no further fresh permission for a new lessee is required. That is what you see brown field, the words. So far as the green fields are concerned, because it's a new one has to dig, one has to do a lot of works thereupon. So for them, there is no period or no restrictions is provided of a minimum production or the removal for initial period. So one can definitely reasonably gather that these are the basic broad concept behind it. So that the mine which is operational, functional, should remain in such state of affairs and continue. And the mine which should be for the first time be operational, then in that event there is a separate clause. 2 years restrictions or something is not operated.
And one more sentence, because this, may I just make that sentence after reading paragraph 2 on the same page lower down? Just read that first, then I'll make the point. What my Lord has said, fortunately, it doesn't always happen so clearly in amendments, but in amendment this time, in B7 double I, then I'll make the comment after that. The Amendment Act had a very nice SOR.
Yes.
And that says this. The present legal framework, exactly what my Lord summarized just now. The present legal framework does not permit the auctioning of mineral concessions. Auctioning of mineral concessions will improve transparency in allocation. Government will also get an increased share of the value of mineral resources. Some provisions of the law relating to renewals of mineral concession have also been found to be wanting and enabling quick decision. Consequently, there has been a slowdown in the grant of new concessions and the renewal. As a result, the mining sector started registering a decline in production affecting the manufacturing sector.
Yes, that is that. That's correct.
And
No.
then, well, it's removal of discretion, option to be the sole method, and grant. Now, well, I am not on this, but this is a fair thing. You gave it for 2 years, you did not give it, etc. 2 years was clearly the window. My objection is, Balas, that this power for a totally different rationale, it should be very laudatory and a very sensible rationale, has now become a endless charter for stipulating something of gigantic repercussions for 48 years. That's why. If your lordships had the slightest intention of doing that new regime of this kind of 48 years, surely what we are reading at page 9 and 10 of my note, there will be some inclination, some indication, I'm sorry, either in the rule or in the section or in the SOR. So what has happened is that the state has suddenly realized, once you start earning money from a source for 2 years, you don't stop it. It should never stop. So the tap should flow endlessly. So they have converted something meant for X to a use for Y. Something meant for the North Pole is being misused for South Pole. This was not the intention without a very fundamental change in the act. You don't have these things by. That's the whole argument. And well, let's just see. I have given the rationale not only of the SOR, which is 3.5 is 2 years. 3.5 para, I say 2 years. But I've given the SOR, of course. Previous para is that this started when your lordships did that judgment bills. This is 2G and 1G. That led to this auction regime. Because there it was observed that first come, first serve created all kind of nepotism. So that's the first para. Then comes the SOR. Then come to my para 3 at page 10. Small Roman 3 at page 10. Once it was decided to have an all-India permanent auction regime for future mineral concessions, the government was faced with a piquant situation which provided for direct structure for the 20 amendments. The government had a large number of mineral leases across the country, approximately 334, which were already operating and may be called brownfield, and were expiring in March 2050. To operationalize the new regime of auction prospective, it was vital to do two things. This is my submission, the heart of my submission. Firstly, press a reset and sync button to get all the old and existing legacy brownfield leases to restart on a common date. That's very important. Somebody is expiring in 21, somebody is expiring in 23, somebody is expiring in 18. You had to have an auction with a common kickstart. The firing pistol was on a common line. And secondly, to ensure that the sudden transition from the existing regime to a new regime, especially in the case of non-captive mine, that is us, which was to start in less than 5 years, should not lead to a huge disruption nationwide. In a nutshell, therefore, the primary objective of the government behind the 20 amendment was to prevent a sudden knee-jerk of supply chains and to actually disruption. That's the word missing there. Disruption of supply chains and to ensure sustained supply of minerals for national growth. Mainly to achieve this laudable objective, a kind of 2-year transitional holding period was prescribed by the 20 amendment, which brought in inter alia 4B, 8B, and 13(2)AA. It was in this context that a limited window of 2 years was provided to ensure continuous supply. But it could never have been intended to be a never-ending continuous process of forced dispatch for 48 years. But on the face of it, forced dispatch for 48 years means that you are ignoring the market. Well, are your lordships in some kind of artificial price control, Essential Commodities Act regime? Take a simple common sense example. If I dictate to you that for 48 years, that is the whole life of the lease, it doesn't matter. You shall sell or buy only after clearing a minimum irrespective of the market. Well, Lordship knows the Karnataka batch of matters which traveled to Supreme Court through the Justice MP Shah Commission. So there was a huge problem there of glut and shortage at alternate times. Justice Shah's Commission report has addressed that. This is a puny rule which kind of ignores that there is a market. Market exists above the stipulation. Thanks to dispatch, then you can do what you like with the market. And the dispatch is higher than many other requirements like the mining plan. So therefore, my conclusion is clause 11. It is
Yes.
therefore clear that the stipulation of 12A would never have extended beyond the initial period. The failure of Rule 12A2 is completely divorced. They realized, brothers, that the intent was this. So they have done one thing. In 21, 10, etc., they deleted 2 years from 8B, much after the regime had kicked in. The parent section 8 capital B deleted only that phrase 2 years. But the rule which kicked it off from year 3 to year 48 continued. The rule was not redone in the light of a deletion in the section, and the argument remains the same.
What was the unamended Rule 12A when they brought in 2020 and then is revamped or reshaped in 2021 by virtue of this? What is the significant or a stark the difference or a distinction?
Yes, just turn to 1A. To 1. Well,
Because I do not find from the book that the unamended 12A is also quoted. Sometimes the author at the footnote or at the bottom of the page quotes that.
we'll get that also. You have to see. We have it. We have that unamended. But just read 12A 1 for a minute. Then I.
No, one was 2020, then another 2021. The amendment came that we noticed.
12 capital A. 12 capital A bracket 1H. Now this is Malas, the insertion in 21. And the main provision came in 2020. The 2 footnotes here are also there. I'm reading 12A.
No, I'm reading because the book says that this was inserted
Yes.
with effect from 20th of March 2020.
I will just 12A.
Yes, 12A. I'm just talking about 12A.
Right. It was inserted
And then
on
then
2020.
then it was reenacted or revamped or resubstituted.
1A. Amendment is nothing.
1A. Okay.
That is 21.
Oh, 1A came on 10th of June 2021. Yes, you're correct.
1C, your lordship says, for a moment, 1C, it says in cases where the minor is executed, on or before the commencement of the third amendment rules 2021, which means for 1st July 2021, the provisions of sub-rules 1A and 1B shall apply after a period of 1 year from the date of such execution or the date.
So there is a moratorium period of 1 year that is provided. Moratorium period.
Now it's just to get clarity. Just keep this open. So you're still holding now.
Yes.
And just go to the writ page 309. Where I've got the actual amendment. Not here, but in the writ, in my writ file.
Oh, writ file.
That is the item fifth matter, not item first.
This is this one. Page
309 is the actual amendment. This is how they amend it. They bring in after sub-rule 1, the following shall be inserted. At 309, 3 lines from the top. This is in 2021 of the July. First July.
That's the introduction of 1A, 1B, and 1C.
That's it. This one also gets clearly good. In case of shortfall in dispatch from the minimum dispatch required, which shall be assessed on a quarterly basis, this is shared. Addition to the amounts payable, refer to for the actual dispatch, also paid to the state government and right? Now just see the original, unamended.
That's true. That is a confusion. That I noticed. Actually, the book creates a confusion.
This,
The bracket should have come after subsection 1, but it is now shown in subsection 2.
after column, that bracket should have gone to, at the end of.
By sub-rule 1.
Yes.
1C.
But it has gone up to 2. That's why we were just, the book is not.
Only the proviso is added.
Only proviso was inserted.
Only proviso.
Under 2. 2 was there. 1 was there. 2 was there. 1A, B, C were
Added.
introduced in 2021.
Now just to complete, just contrast this with page 244 where the unamended is given. Now, this is the amendment. You have to keep the book also. The book is enough because the book has the amended.
Yes, amended. I found.
First is 244 of the rate.
Now, after seeing this, 309, means 309, it is.
It's the same as the book.
And clear.
It's the same. Now, come to 244, which is the unamended. As it came in 2020 originally, this is how it's came, prior to 21.
Yes.
So, Malas, 12A additional conditions. 12A1 is the first one, which came in 2020.
Yes.
And then it had 12A2. The new lessee shall ensure that the annual production beyond 2 years from the date of execution of new lease is equal to or more than the annual production by the previous lessee and shall subsequently work out and implement an annual production plan to ensure that the mineral resources are fully exploited under the lease, failing which the appropriate action in accordance will be initiated. So, your lordship had the second part of 1 made into 2. What is now the second part of 12A1 was actually 12A2.
True.
This whole thing is added. 12A ended here. 240. That is all there is of it. So we'll actually come back to it.
Yes.
Now I come to the third ground, which is of unconstitutionality, which is the mining plan, which is at my page 11.
Yes.
Rule 12A as a whole is also ultra vires 5 and 18 to the Act, since the said section gives primacy and mandatory efficacy to the mining plan, which in turn specifies a phased and planned manner of mineral production every year, which in turn is in complete contradiction to the compulsory dispatch regime purportedly created by 12A. Additionally, for the same reasons, 12A also contradicts Rule 10, 11, 13, and 17 and Rule 35, which remain operative and unchanged and give similar primacy to the mining plan. I can't say that Rule 1 is violative, unconstitutional, ultra vires Rule 2, but it is ultra vires the sections which give primacy to, and also totally in contradiction to the existing rules which have not been changed, which are in conformity with the section. That's the argument. How kindly see. The mining plan is a vital linchpin, foundational document of all mining regimes and all related rules. The mining plan comes into operation only after approval by the Apex Scientific, Technical, and Statutory Central Government Regulator, the Indian Bureau of Mines. The approval of the mining plan is traceable to 5(2)(b), requiring the central government to approve the same. And the central government's main and only regulator in this regard is IBM, which is dealt with under the rules, specifically Rule 10, framed under Section 18. It is interesting that while a very large number of functions and activities in the realm of mining are specifically delegated to state governments, there are significant exceptions where the central government alone is retained as the persona designata. Approval of the mining plan through its principal organ IBM is one such significant function. Both the concept of the central government IBM approval as also the concept of mining plan exist in the statute and the rules from the inception till 1957, decades before the introduction of 12A. No relevant or material parallel alteration to the IBM approval or mining plan regime was made when a delegated legislation called 12A was introduced. The Lordship didn't amend the Act or anything else. The heart of a mining plan proposed by the lessee and approved after much analysis and scrutiny by the IBM is the specification of production units in each year. This is also vital since it is intended to ensure a systematic, scientific, non-exploitative, and phased sequence of extraction, also keeping the paramount consideration of environment, ecology, and safety in mind. It is tried that there can be no removal nor any compulsory dispatch without production. Now, one of the arguments anticipated is that you are talking of removal. This one is the mining plan talks only of production. Naturally, it has to talk of production only. There is no removal possible nor any compulsory dispatch possible without production. There is a patent mismatch between the mining plan IBM specified regime specifying production figures for different fields and the suddenly superimposed compulsory dispatch regime. And my Lord the Chief Justice asked me about maximum, etc. Already answered. The two cannot and in fact are never in sync. The two cannot and in fact are never in sync. And consequently, the regime under 12A violates the superior hierarchy of the statutory mining. Just see a few sections first. 5 is restrictions on the grant of PL or ML. No mining lease shall be granted by the state government unless it is satisfied. It's an absolute prohibition. Right? No and unless. There is a mining plan duly approved by the central government. So you are approving it, but the basic chap who's first approving it before you are the state government, is the central government. The very next section says central government. Or by the state government in respect of such category of mines as may be specified. Sometimes central government says for these categories the state may approve. That's not our category has to be central government.
Correct.
Section 18. Mineral development. It shall be the duty of the central government to take all such steps necessary for the conservation and systematic development. Very important. Minerals and for the protection of environment by preventing or controlling any pollution which will be caused by prospecting or mining operations. And for such purposes, the central government will by notification the official gazette make such law. In particular and without prejudice to the generality of the foregoing powers, such rules may provide all or any of the following men. The opening of new mines and the regulation of mining operations. Then the regulation of the excavation or collection of minerals from any mine. The manner in which the authority by which direction may be issued to the owners of any mine to do or refrain from doing certain things in the interest of conservation or systematic development of minerals, or for the protection of environment, or by preventing or controlling pollution which will be caused by prospecting and mining. The maintenance and submission of such plans, registers, or records as may be specified. Just pause here for 5 seconds. Not that I'm not applying it to the facts of the case, but just take an example. Well, this mining plan is much more important than we tend to think. If it is approved, then it goes on. Take, for example, I'm not talking of this case, it may be that coal is a different thing. But take, for example, our commitments on all these Kyoto and all these protocols for carbon footprint. So the carbon footprint is not a sudden press button that today I will become 0, today I will become 20%. It says first year I go 10%, second year I go 15%, like that. Now, that is not for me. That is not for the state government. The central government sits on a mega foreign affairs in a Kyoto protocol and decides that. Now, individual case may not matter, but take collectively, that all state governments across the country start stipulating minimum dispatch requirements, which are completely at variance because they say a very high minimum dispatch because the carbon footprint must increase. This power is given to the central government by statute. I'm reading statute. Now, Manas, come to the rule below this. We finished the statute, now come to the rule. Mining plan, no mining operation shall be undertaken except in accordance with the mining plan, which has been approved by any officer in the IBM, duly authorized in writing by the Controller General, Indian Bureau of Mines. He is the top fellow scientific head there. Pursuant to 5(2)(b) and in accordance with 15, 16 and 17. Is in accordance with the system established by the state government for preparation, certification and monitoring of mining plans. That is some other issue which we don't go. We have to go to the IBM one. The mining plan shall incorporate a tentative scheme of mining and annual program and plan for excavation from year to year for 5 years. So it's a control all time. You can't get a charter for 50 years. I must go back in 5 years to you, and you can again put all kinds of restrictions on me. Rules, also just remember one thing, we are talking of one part is foreign affairs, Kyoto Protocol, global issues, which no state and no individual can. If you have a collectivity of this carbon footprint not controlled, then you may have no mining plan necessary at all. Take another example. In 5 years, the exploitation of this mine, you may be having some totally different material which is used in this. When titanium came, when tungsten came, things changed completely. These are meant for scientists. You may well continue after 5 years, but their perspective about how much you will mine, how you will mine will change with the evolving technologies and concerns of society of that day. It is not an individual stipulation by a subsequent delegate legislature by a state saying, no, no, you keep producing minimum. You must produce minimum. 17.3. Modification and review of the mining plan. The mining plan, once approved, shall be subject to review and updation at an interval of every 5 years. This is the control, very important control. They don't leave you. It's not an open charter, not an open license. But once you got approval. Starting from the date of execution of duly executed mining lease, at least 180 days before the expiry of every 5 years, the lessee shall submit a mining plan 6 months before I have to submit for mining operations for a period of 5 subsequent years, prepared as per 15, it shall be disposed of as per 16. A holder of a mining lease may seek modifications in the approved mining plan as are considered expedient, keeping in view changes in the business environment, or for facilitating increase in production capacity, or in the interest of safe and scientific mining, conservation of minerals, for the protection of environment, or any other reason to be specified in writing by the holder of a mining lease. Any modification to a mining plan shall be approved by the approving authority that approved the initial mining. Well, these are mega considerations. These are not the narrowest of narrow revenue earning considerations for a state. Look at this language, Willis. Business environment, facilitating increase in production. Well, today in the war, we need some special rare. I'm giving examples only. We don't have, unfortunately, enough rare minerals in India. But for war effort, we need more. The Lordship may have some Willis approach. Or in the interest of safe and scientific mining. My own case, I said it is not safe enough. So they applied, they discussed this in up, down, this, that, then they stipulate. My own case on the facts of this case. Then was scientific mining, then conservation of minerals. Because one bird in the hand, 2 in the bush. What are you going to do? You can have all the birds together today, or you want to spread them out over 5 days. In case of modification to a mining plan, the provision of Rule 6 shall apply mutatis mutandis. In case of a system established, that does not apply. Now, 29. Conditions of mining lease. Every mining lease granted pursuant to Rule 27 shall be subject to such conditions as may be agreed upon in writing between the grantor of the lease and the lessee, provided that the lessee shall be obligated to comply with the provision of this is part of the impossibility. Once person says violate the law, where the other person. Comply with the provision of rules made under 18. Comply with the provision of chapter 5 regarding preparation of a mining plan system. Operate the mine in accordance with the mining plan. A de facto mandamus to violate the law and to do the impossible. D. Provide the state government with a security deposit of the value of 5 lakh per hectare, etc. Rule 10. Competent authority as well as the Controller General or an officer of the IBM authorized in writing by the Controller General shall be the competent authority to take decisions with respect to mining plan approved by any office of the Indian government. But on this provision of the rule, is it fair to say that that counter affidavit that this
Understand, because you says that everywhere it is a primacy is given upon or a supremacy is given on a mining plan to be approved by a competent authority. Even a rule 10 talks about who is a competent authority.
And which you are usurping and transferring de facto. In fact.
And then many of the sections of the rules have a negative words and therefore make it more mandatory or imperative on the lessees to follow.
So you first enact an act where you give an indemnity. Notwithstanding the mining plan, if Mr. Singhvi does something contrary, it shall be covered by this.
Correct.
This is just it's done in an unthinking way. If you are trying to work, actually the rule is a very small, puny thing, which has come for the 2 years post period, which they are now exploiting, and it's become much bigger than the main act. Now come to Rule 11. Mining operations under mining lease no holder of a mining lease shall commence or carry out mining operations in any area except in accordance with the mining plan. So again, it repeats. My lord is repeating 11. Approved, modified, or reviewed by the Indian Bureau of Mines or prepared and certified by the state government, that's separate category. If the mining operations are not carried out in accordance with the approved or certified mining plan, I'm reading the bottom of page 15, or any information contained in the mining plan is incorrect, misleading, or non-compliant with applicable laws, including rules, the competent authority may by order suspend all of the mining operations and permit continuance of only such operations that are required to restore the condition the mine is envisaged in the approved facility. Every approved mining plan shall be subject to review and updation. Now just pause here. My lord does not decide unconstitutionality by transient stands on counter affidavits. Let me meet it frontally once. Today, the state government and the central government is one. Because the central government is saying an authority on affidavit that this whole specialty is subordinate to the contract. That will not determine constitutionality. Today, this says that you shall be subjected to suspension of technically matters tomorrow. My learned friend, the state says produce 1 lakh this year. The mining plan says produce 10,000. I produce 12,000. What is the reading of others 2 at page 50? Finally see 2.
Not in
You must
accordance,
suspend.
not in accordance that you may suspend.
Suspend. Now, whom do I obey? Whom do I follow? And in any case, this affidavit stand does not change constitutionality. But has the affidavit changed this rule? And have they given me an indemnity that if I do this, this fellow will not sue? This is on principle, your lordship decides. The answer I know is going to be that this is only an imagined problem because we are saying that we are the prosecuting authority. We are not prosecuting you. Why don't you do the wrong? That is not the way to look at constitutionality. With greatest humility and respect.
If there is a sword hanging above your head, that may fall at any point of time.
I think if it doesn't fall.
That's why I'm saying,
Not
but it
changed.
still is hanging.
Hanging. So the rule is not changed. This is the law. And there's a complete contradiction.
Threat perception is always there.
Now come down to page 16, rule 35.
This says that if there is a deviation or is considered compliance, then
There is a no justice.
the mining plan limits the production. And the dispatch says more, then that even what to do? If I produce more, I liable for a suspension. If I don't produce this one, then I'm liable for this liability for this, not dispatch.
16. This is yet another rule. But that is one facet, safety, one facet, this is sustainable facet, sustainable facet. Every holder of a mining lease shall take all possible precautions for undertaking sustainable mining while conducting prospecting, mining, beneficiation, or metallurgical operation. Every holder of a mining lease shall monitor his mining and allied activities as per the notified template of scenario in the format prescribed in his behalf by Indian Bureau of Mines from time. All this is given to go by. Indian Bureau of Mines is saying, we go ahead because I'm in the central government, they filed an affidavit. And shall submit online its self-assessment report before the first day of July every year for the previous financial year, along with the soft copy, etc. Covering the mining lease and an area of 2 kilometers from the lease boundary to the regional controller or the authorized office. Now, Willis, I'm giving only a specific example how the dialectics of this work out. It's on the record here, Willis, these 4 letters in C.9. It is not a very simple push button thing. There are concerns expressed. We are not a permanent operator. One of the largest for this country with reputation. You have to engage with them and see what happens here and see now how casually they are violating. Come to C9. To take a specific example in year 4, while this is a specific factual example, a word in marriage, nothing outside. While the mining plan stipulates a figure of 0.6, the compulsory dispatch, now this is 2 plus, more than double, more than double. The mining figure is 0.6 because the top technical expert IBM agreed with me that the need to scale down production on account of serious safety concerns. Now let us see the letter. Please turn to this very quickly, these 4 letters. 310 is the first letter.
This is from 31035, writ petition.
Well, that's all the fifth petition. All pages are fifth petition. I mean the first and the fifth. So pages are only of the fifth.
Hey,
Which is 22nd December 21. This is from me to the government of Orissa, Ministry of Steel and Mines.
yes.
Ignore one, and I'll just read the relevant portions. It's a long letter. Come to the relevant portions. At 312. Further, Sukhinda mining block faces unique challenges of mineral mineable reserves in open cast mining and triggered need for us to take up underground mining project for the reason mentioned. Sukhinda, now this is one very important because this happened partly in Dehradun. We tend to forget that. Open cast and underground. Kindly see this. Sukhinda Valley constitutes 96% of the country's chrome reserve, and mining at Sukhinda was undertaken by Tata Steel since 1983. We are a premier agency, we are a very professional. The mining list was retrenched at various renewals. It was left with 406 hectares, while its expiry on March 20. It was worked mostly with open cast mining. However, keeping in mind the sustainable chrome ore production, lessees completed the feasibility study with the noble intention to start the underground. However, after promulgation of MMDR Amendment Act of 2015, the project could not be taken up due to uncertainty of continuation of mining beyond 2020 in view of start of oxygen involvement of huge expenditure. Now, as a matter of stand, the open cast mining can run for the next 2-3 years with available open cast mineral reserves of 3.9 million tons, and switching over to underground mining will become. And now this is a fork in the road. In mining, the biggest fork in the road is open cast versus underground. A very clear two separate universes. However, it is seen across the world, underground mining is capex intensive and has long gestation period of more than 5 to 6 years. Due to existing geotechnical challenges involved in Sukhinda, underground mining needs to start in hard strata below 300 meters from the ground level, and development of such extent with all underground infrastructure challenging itself. So it is most likely there will be some period of time when the open cast mining would have to be exhausted and underground mining could not have been started. In such a situation, it will be almost impossible to maintain 100% or more production from third year onward. Now, they can examine scientifically, say it's all bunkum, you don't accept. Only they can do it. Indian Bureau of Mines has reviewed all these aspects and have approved the mining plan of Sukhinda, which should be guiding document for all matter in time to come. It is submitted the target set out under NDPA is not in alignment with the quantity approved by the Indian. MDPA is the agreement contract. A note is attached. If you see the second one at page 329. At 3:30 are the minutes. Meeting was held on 4th of March under the chairmanship of Director of Mines Orissa. Presentation was done. Come to this first document. Sukhinda was the first document.
Yes.
At 3:30. Sukhinda mine had only 52 lakh tons of chrome ore mineable reserves through open cast mining methods as per approved plan by IBM. So it's going through a process. It's not just for some knee-jerk. After meeting the targets of 13.6 lakh tons for 2 MDPA years, the remaining reserves through open cast mining by beginning of third MDPA would be 24 lakh tons. Considering the MDPA targets of 17 lakh tons per year from third year onwards, the open cast reserve will exhaust within 1.5 years. I hope I'm clear. Total left is 24. You are saying take 17 in 1 year. So 1.5 years, everything will be over. The depleting open cast reserves of chrome ore has necessitated initiation of the underground mining project as per approved mine plan by IBM. There is a delay in starting the underground by more than 1 year against approved mine plan, considering the pandemic and complexity. Director to come up with approved mining plan with timelines. So these are all matters left to a scientific body. Now comes the third letter at 331. We are hereby submitting the draft copy of the modification of mining plan. And remember, Manas, this is just a press button thing. The moment I do one less than the stipulated minimum, I'm chargeable. They are not bothered. Open cast, deep underground mining, effect or anything, nothing. They say, look, we gave 10, you gave 9, or 1 you pay us. That's the approach. I'll come to 331. We are hereby submitting a draft copy of the modification of mining plan prepared under Rule 17, along with progressive mine closure plan under Rule 23 over an area of 406 hectares. Please find enclosed the processing fees and money. But pause here. The Act provides, the Lordship has the Act providing for closing a mine. Very detailed provision. Taken to the logical conclusion, it is totally dehorsed. They say, we don't care, no closing, nothing, you keep producing. All those rules are not changed. Rule is cited here, Rule 23. Then next page, new mining plan, 332. Now, this is an important, 332 is very important because it is the IBM. It's the IBM. That's why it's important. 22nd of July. Government of India on top. It's quite bizarre. Government of India is saying the counter affidavit, Central government is saying something else. Approval of modification of mining plan of Sukhinda, along with progressive mine closure plans over an area of 406 hectares in Jajpur district, submitted by Tata Steel, etc. Your letter so-and-so, this letter so-and-so. In exercise of the powers conferred by clause B of section 2, 5, etc. Fourth line. I hereby approve the modification of mining plan of Sukhinda bromine with the progressive mine closure plan over an area of 406 in Jajpur, submitted by Tata. This is subject to the following conditions. First is without prejudice to any other law. Proposals is based on the lease map sketch. It does not imply the approval in terms of the provision of MMDR, the mineral concession rules. So if you are violating some provision, then I'm not. Come to 6 now. This approval has been given for mining proposal for the year 22-23 to 24-25 and are subject to the validity of the lease period. Now let's just see 2 pages later. Come to 334. Come to 334. And in that heading, come straight to 336, which is part of the modification of the plan. H334 is the attached document.
Correct.
Attached document. Relevant is 336.
Yes.
Heading H.
Yes.
Life of mine.
Yes.
The remaining reserve for Sukhinda open cast mine on 1 April is 4.5 million tons at the required production rate of 17 lakh tons per annum from third year. This required is not by mining plans. It is required by you, Mr. State Government. The open cast mining will sustain for approximately 2.5 years only. Underground mining is therefore essential. However, underground mining is a project capex intensive, long gestation of 5 to 6 years. Now, I will just see. For 6 years, I will keep on paying for not producing, not selling, for not dispatching. This is an absurd mismatch. So there will be a period of inevitable production discontinuity of approximately 2.5 years in between end of open cast and beginning of production from underground. In such a situation, it would be almost impossible to maintain the required production from third year onwards. So after due diligence of the technical and safety factors and to ensure a smooth transition from open cast to underground, this is what I propose. Now, this is the most, I'm going to invest and make it an underground blasting thing. So I propose this plan. But for 5 years in between, I don't care, says the state government, you jolly well pay 5 charges. That is why their own letters say, but there are no guidelines, there is no system. And the problem is, what you've done is a square peg in a round hole. You picked up a square peg without seeing the entire terrain. You try to fix it into that. There's no matching. There's no changing of other provisions. Now see this. Proposed production plan period. Your lordship has got
Yes, yes.
24-25. Proposed production from underground, from open cast is first, underground is 0. What do I do till all these years? Well, that total will come back to 6, ultimately will be stabilized again. You must be, unless you have to work with me. We are not antagonistically fighting. We can work together and get a proper system. Ultimately, Manoj, you will be having a stable system. But you can't have a press button that you must pay me on pain of this thing. Nobody is saying I'm cheating. Nobody is saying I'm producing and selling off quietly. I'm not able to produce. And Manoj, anybody who knows anything about mining, who suggests that we switch from open cast to underground and start continuing the dispatch requirement, means he's ignorant about the mining system. Nobody can do it in the world. Now come back to my parameters, C9. They are all kind of facets of unconstitutionality, utter non-application of mind, utter arbitrariness, Article 14, everything all together. Now come to C9 is over C10. This is at page 17. Furthermore, clause 10, which is the contract. Now, this is again quite amazing. How do you file a counter? In normal cases, we would say between private parties, the lordship will say perjury. We don't say it because it doesn't get us anything. And the lordship has got enough work to do otherwise than to start perjury proceedings. Because can a government file with this just C10? This is made by you, not by me. MDPA shall be subject to mining plan. Mining plan in compliance with applicable law. Mining plan applicable pursuant to clause B of 2 of 5, or if the case may be 8B, etc., etc., shall be complied with by the successful bidder all times. The successful bidder shall also comply with applicable law in relation to the conduct of mining operations. They are giving it very great importance, but the affidavit is not. It is therefore astonishing, to put it mildly, that the central government at para D of page 50, she need not go there. Its counter affidavit which came last month on 8th of October purports to say, quote, it is important to mention that the mining plan is subjected to MDPA and MMDR Act of 57 and the rules made thereunder. Any mining plan not in conformity with MDPA and MMDR Act with rules cannot sustain. So just see this sentence, pause here. I have no problem with MMDR Act. If the mining plan violates MMDR Act, we have no problem. But the same thing can't be applied to, it is subjected to MDPA. But even on normal principles, since when, forget this case, get the clause, when does the lordship have a contract trumping a statutory context? There is some very special provision. This is even more surprising for the simple reason that the central government acting through its apex regulator, namely the IBM, is the custodian of the mining plan and its strict implementation. This strange stand of the central government is variance with the elementary principles of law also, wherein a contract would never trump a statutory document like a mining plan. Except when the statute itself says so. Just see this para 151 of common cause. These counters are being filed without regard to the law. Without regard to your contract, without regard to the law, without regard to case law. Common cause is a very famous judgment, well known in mining law. Let's take the digest, give the digest, please. We have got the full judgments also, so this will save. To the other side. The other side. Look, in this digest handed over at page 10. Common cause. I had occasion to assist the court in this matter in para 151. In our opinion, section 21.5 is applicable when any person raises without any document, any mineral from any land. In that event, the fee comes entirely to law. From such person, the mineral so raised or where a mineral already disposed of, price as compensation. The words any land are not confined to the mining lease area. As far as the mining lease area is concerned, extraction of a mineral over and above what is permissible under the mining plan or under the EC undoubtedly attracts the provision of 21(5) without being extraction without lawful authority. It will also extract 21(1). So clearly, brothers, the penal consequences follow because of mining plan, which is equated to EC, both of which are statutory. And here an affidavit is saying whether the whole thing is contract. NDPA very contract common ground. So C.12 brothers. C13 this issue ends. Then we turn to our fourth ground. D. Now separately, brothers, on the Article 14, now last three grounds, that is D, E, and F, are Article 14 grounds. So this is the first facet of Article 14. Now here, brothers, although it's a very fascinating journey, time can be saved in giving the 4 steps which I outlined for you. Independence till Royappa. Royappa solidified by Hasya and Shetty, etc. etc. Then, brothers, Maneka, procedural due process. And then finally, brothers, Jara Bano and manifestly arbitrary full due process, substantive also. That's the 4 flows, because we are now dealing in section D, E, and F with Article 14. So first I'm laying the ground of the width and reach of Article 14. Somebody asked that what is the most important article in the Constitution? This of course just we said 21, because it is life. Actually, without doubt, and also the judges probably will agree, I don't know. The most important operational article is 14. Your lordships cannot have the width.
That's the equality principles.
Equality, discrimination, arbitrary.
That imbibes many facets.
Everything in daily life, what matters most in your lordships daily adjudication is frequently this. So in any case, 14 and 21 are the hallmarks of our constitution. If you were to choose in part 3, there is no doubt that the choice has to be these 2. Now let's just see that development. I will not read any of the cases at the same time. Stage 1 in D1I. D1I at page 18. Stage 1 is anti-discrimination concept and classification concept. I've cited Dalmia, Charanjit, Tendulkar. Commission was there involved in that. Then in II, I have cited anti-arbitrariness facet introduced by the seminal judgment of Royappa. It is a constitution bench. It's a constitution bench, and I have given one. Your lordship, I have to just note down. I'm sorry. I have to note down the hand to save time. We should always in Malas, you are not given in the note. In Charanjit, it is para 38. Just note that. In Dalmia, it is para 12. In Royappa, it is para 85.
Yes.
Then, in Small Roman 3 comes that 3 or 4 very, very important cases: Maneka, Asya, and Shetty. Plus, people forget that this fellow Ravanna Shetty bid for a tender. He established tremendous law in Article 14. The last 2 paras he lost for 5 months from him. It's a case actually cited in lectures. The writ was discussed. 5-month delay till para 36. I remember it was Article 14. Everything short of substantive. In last 2 paras, the writ was discussed because of a delay of 5 months. Anyway, now these cases in Small Roman 3, this Maneka is 7 judges. And the para is 7. This variation is there, not there.
And then come read from 4 onwards. So Maneka Malas is traditionally put in the slot of the fig leaf of Malas procedural due process, although it is the borderline. Now let's come to 4. However, the traditional wisdom surrounding the deliberation of the Constituent Assembly to the effect that no substantive due process could be introduced to Indian law continued to the position in Indian law even after
That you have already incorporated. I said at the very outset. I said at the very outset that there was a debate on a due process of law to be incorporated. You have incorporated it.
Fine.
Yes.
Skip that. I also pointed out how the Japanese constitution language came in, etc. Let's para 5 and skip it. Then was 6. Substantive due process doctrine is 6 and 7. Now 6 is that it is not merely procedural due process, and 7 is that invalidation of substantive legislations, which is why substantive due process. And the theology is given in between, whether Shaira Bani, Notte Johar, and Joseph Shine. Well, I will take the liberty of taking giving to your lordships court master just a small slip with the parameters. Some of them are missing.
Yes.
Wrote it down in lordships and later on just for
Yes.
Of course, the digest has the actual parameters.
No, it's no different.
Now come to a summary which I will read, because it's a bare summary only last year of all the substantive due process. So the case development and evolution, the trajectory of the evolution of 14 years summarized. Now this case kind of solidifies it. This para small Roman 8, page 19. This is the electoral bond case.
Yes.
It is now a settled position of law that a statute can be challenged on the ground that it manifestly arbitrary. The standard laid down by Justice Nariman in Shaira Battles has been cited with approval by the constitution benches in Navtej, Joseph Shine, and Joseph Shine. Courts, while testing the validity of a law on the ground of manifest arbitrariness, have to determine if the statute is capricious, irrational, and without adequate determining principles or something which is excessive and disproportionate. This is pure substantive due process, and your lordship has almost all these phrases applicable to the facts of this case. Capricious, whimsical, irrational, no adequate determining principle, excessive and disproportionate. Disproportionate is coming as a separate head. A provision lacks an adequate determining principle if the purpose is not in consonance with constitutional values. In applying this standard, courts must take a distinction between the ostensible purpose, that is the purpose which is claimed by the state, and the real purpose, the purpose identified by courts based on the available material, such as the reading of the provision. Now, page. But just note, there is no real purpose here except real purpose and apparent purpose is money. Money. If provision is manifestly arbitrary, then 201. And most kindly just give me 5 seconds. Something which is born in the context of a reset button. On what reasoning does it say that this shall continuous interfering in the market process for 50 years? For 48 years, we shall keep on insisting on a stipulation. Where is your power? Born in a different context, apply in a different context. Bold space highlighted at bottom of page 20. The second is the reading of Article 14, which includes the facets of formal equality and substantive equality. Article 14 consists of 2 components. Equality before the law, which means that the law must treat everybody equally in the formal sense. In the formal sense, somebody jokes, it's like a French lady. It's actually one of my checking up showed that she didn't ever say it, but she become famous in history as the person to have said something she never said. Equality formal means that if you can't have bread, please have cakes. You have the option. So therefore, mothers, equality before the law, which means that the law must treat everybody equally in the formal sense. Equal protection of the law signifies a guarantee to secure factual equality. The legislature and the executive makes classifications to achieve factual equality. The underlying premise of substantive equality is the recognition that not everybody is equally placed and that the degree of harm suffered by a group of persons or an individual varies because of unequal situations. So the correct phrase is don't treat equals unequally and unequals equally. Of course, create a classification and then justify to the court.
Then let us come to the lower quotation. In the INRI, Delhi laws is picked up the most famous case was way back in 1951. INRI, Delhi, Justice Fazal Ali. Just come to the bottom of 21. It cannot abdicate its legislative functions, and therefore, while entrusting power to an outside agency, it must see that agency acts as a subordinate authority and does not become a parallel legislation. Just pause here, Manas. We will sit over a cup of tea and work out. The word is a workout. I not seen the section.
Yes,
How
yes,
work out,
we have
when
seen.
work out, which way work out. What happens if we don't work out? And the workout is only one way, Manas. There is no workout as far as I am concerned. They will stipulate. Completely vague. Manas. This is a delegation completely. And I'll come to a letter where my learned friends complain that look, how do I operate it? I'm coming to the letter on the file. Then verse 204, page 22. The above discussion shows that manifest arbitrariness of a subordinate legislation has to be primarily tested vis-a-vis in conformity with the parent statute. Therefore, the ultraviolet is also. Therefore, in situation of subordinate legislation is challenged on the ground of manifest arbitrariness, this court will proceed to determine whether the delegate has failed to take into account very vital facts, which either expressly or by necessary implication are required to be taken into consideration by the reflection or say the Constitution, Indian Express. In contrast, application of a manifest, this is important one. In contrast, application of a manifest arbitrariness to plenary legislation passed by competent legislation requires the court to adopt a different standard because it carries greater immunity than subordinate legislation. We are here on a subordinate. We concur with Shaira Banu that a legislative action can also be tested for being manifestly arbitrary. Much more so one of the delegated. Much more. However, we wish to clarify that there is not to be a distinction between plenary and subordinate when they are challenged for being. I'm just citing this to say that I'm on a lower level. I mean, what I'm challenging is a lower level. I'm on a higher level. My case is for sure. Consequently, now just this one parameter version is rising. Consequently, rule A2 should be analyzed in the context. What is that context? Just see this para D3 is very important as a lordship rises. 12A2 is in stark contrast not only to 12A1 but to 4B and 8B. 1. It has no 2-year restriction. 2. Self-professedly talks of a period till the end of the lease from 3 to 50. Unlike the specific contextual guidelines in 12A1, which is average of annual production of 2 immediately preceding years, 12A2 is conspicuously absent by even a remote attempt to provide guidance as to how a compulsory dispatch rule is to be operationalized from year 3 to 50, and it simply uses the phrase annual production by the previous lessee. Thus, the language of 12A2 is technically distinct from that of 12A1. 12A1, while suffering from other constitutions, but does not suffer from the vice versa. The language, on the other hand, is completely new. It is not clear whether the expression annual production of previous lessee, now this is the expression used, means the annual production of the entire period of the previous lessee or any specified period. Not 2 years, not 1 year. No guidance is provided as to which year annual production is to be taken, or whether the previous lessee's annual production over a particular length, what is actually happening in actual cases, whimsical. You pick up the spike year. You don't pick up the down year. Which year 2, year 20, year 5, nothing. Then was to muddy the waters further. 6. 12A2 also casts an obligation to subsequently work out, and this is the vagueness, subsequently to work out and implement an annual production plan to ensure that the mineral resources are fully exploited. I wish working out is so easy. Ex facie, the latter part is directly contrary to the first part, which forces lessees to maintain an equal to and more than the annual production of the previous lessee. Annual taken for the highest he produced, or the lowest he produced, or the average. We don't know. This is further compounded by the proviso, which then says 80% should be dispatched. Furthermore, while mandating compulsory dispatch, it provides for no specific adverse consequences like 12A1 for violation of this requirement. Indeed, 12A2 appears to have completely missed out the basic rationale of a 2-year rule found in all the sections and rules, which was to prevent disruption of supply chains. Ex facie, this raison d'etre cannot apply in perpetuity from 3 to 15. Continue. D4 is a special letter. Continue.
Yes, yes.
I am happy to continue. Not sure.
Oh, no, I didn't notice. It is already. Detaining a hungry man is not advisable. Yes, that Dr. Sibu. Yes,
May I have your lordship pleasure to
yes.
seek an indulgence at some point of time, and as early as possible I can come and assist the court. And
Yes.
I should be in good competition with my learned friends who are there. And in intellectual mining which is happening there, I could also be part of that.
It's a churning of the intellectual.
So anytime, maybe around
I was suggesting a subject of the entire.
in the second week of December, when it's possible for the court to give me. Third week, I think, 15th or 16th of December, if that's convenient for the court.
Well, one thing I was saying,
Yes.
we learned AG may consider this. At the moment, we just confer amongst ourselves, Mr. Dwivedi and Mr. Subramanian are here. Since we're over, may be a little disturbing to your lordships, but if it is our side, can finish by tomorrow, continue. So maybe in the morning, afternoon, so that we can try and do. That's one.
Yes.
Two is, Malas, either we request my learned friend to make it earlier if he can. I know. Or if he Malas insists on that subject to your lordship calendar, if he insists on 15, 16, then my request would be just 3 working days thereafter. 21, 22, 23 is working.
The difficulty is, Mr. Attorney General, because the moment they come and finish, I cannot trust my memory.
I understand that. I can't have an answer to that.
But still, though internally I am very confident that I will not forget anything, but still.
Yes.
So let them finish off the matter.
Very well.
See, and then if you can make it a little shorter, we can complete it. That is what I request.
That will be my privilege.
Yes.
I'll try.
Let us see how it comes out. Let us see.
Very well. I'll wait your lordship's command. Right.
Yes.
Obliged.
So my lords has now reached page 22 of my note. The 3 the lordship will start from.
Which one?
Page 22, D3.
That you have already placed.
No, that's about where your lordship stopped. I didn't do all of it. Now, just very well, your lordship is right that I've done most of it. D3, my lord, will kindly note, because now we are ultimately it is these factual, firmament, and parameters implicate protein in the larger. Protein is otherwise an abstract concept. The lordship has to apply it. So the cumulative, and no one single straw breaks the camel's back. I'm saying the cumulative impact of ISA 9, which is itemized by me, should have an impact directly against the Article 14 mandate. That's one part. The second part is, again related, where I had said those 2 letters in D4, which I was coming to. Just bear with me in these 2 letters. I think it's enough to read them here. Kindly turn to the letters. I quoted it, but go to the actual letter at 438. Now this is, fellas, ultimately all of them go towards the vagueness, inoperability, lack of guidelines, lack of flesh and blood into how to operate something. Not just giving a declaration, subsequently there will be some workout.
Yes.
So now this is not me. And I'm going to invoke before Lordship's kind permission the doctrine of contemporaneous expositio also. This is them writing at very high levels. So come to 938 first. See the first letter.
Yes,
No. Sorry, that page is 438, not 93.
yes, I have got annexure
This
58.
is 26th of September.
Yes.
Government of India, IBM writes to the state government, and to the government of India, well, the department, the secretary policy, comments on the representation of certain mining companies regarding requests for relaxation of minimum production and dispatch requirement under MDPA signed as per Rule 12, capital A. I feel Lordship will come to the bottom of that page after 4 capital D.
Yes.
That is also seen.
Yes.
Total 17 iron ore leases which expired under the provision of 8A66 of MMDR Act were auctioned by the state government. The details of pre and post auction data on production, resources as on date of auction of lease and life of mine based upon the production committed in the mine development agreement are placed as annexures also. A brief summary of the yearly mineral production by these leases pre-auction for these years, that is 15, 16, 16, 17, 17, is given. Turn to the table on the next page. It's only written as 9, actually 439, something like that. To the page numbers. Yearly mineral production 33, 44, 44, and then 40 is the average of the 3 years. It is further mentioned that Rule 12A, and I'll skip that because 12A. After 12A, just above the table, the summary of mineral production done during the year 1819 and 1920, immediately preceding the expiry of these leases, 17 is given below. Lordship is very important. Lordship will see the practical non-operation. They are telling me I am the practical man on the spot. How do I operate it? See that. The summary of mineral production done during the year 1890, immediately preceding the year, is given below. So it's given 54, 71, the average is 63. It can be seen that the average production in penultimate 2 years, that is 1819 and 1920, from lease expiry, jumped to 63 million from average production of 41 million in the preceding 3 years. When I use the word spike and drop, the Lordship noted that word I use. A jump of 22 million tons, 155%. The average production of these 2 years was 40 million, which is 65% of the average of balanced 2-year production. The further analysis of the production post-auction in the year 2021 and 21-22 clearly indicates that the production from the 17 leases in the year 2021 is about 24 MT, which is lower than the 80% of average production of preceding 2 years, 1819, 1920, due to the time taken in auction, transfer of clearances, and restart of mining operations by the new lessee. However, the production was ramped up about 52 MT in the year 21-22. The figures of pre and post auction dispatches from these 17 leases are placed as Annexure 2. Similarly, an analysis into the dispatch figures reveals that the dispatches also came down to 14.5. Then in the year 2021, again rose to 40 in the year 21-22. However, additionally, around 13 MT was dispatched by the previous lessees under rule so-and-so, etc. during the year 2021. The production of iron ore in the country, now they are doing a full analysis, and it's not me. This is a practical, real problem of vagueness, complete arbitrariness. The production of iron ore for the all India basis, 206, 244, 204, 256 years are given, 4 years are given, respectively against the total domestic requirement of 180 MT on an average. It clearly shows that the supply side of the mineral is adequate, namely domestic demand. In fact, it's a glut. It is also pertinent to mention that export duty has been levied on all grades of iron ore pellets very recently. Then they quote us that rule again. An analysis of production dispatch in accordance with Sub-Rule 12A2 of the Minerals Concession Rules, considering production committed on MDPA is the agreement bills, presents very interesting and contrary scenarios. It can be seen that in case of 2 leases out of 17, the production needs to be ramped up to unsustainable levels to exploit the resources over the balance period of leases, which is against the norms of optimal and sustainable mining, and defeats the very tenet of Honorable Supreme Court's decision for intergenerational equity distribution of natural resources. Further, in the others 14 cases, the resources are getting exhausted much before the lease period. 7 leases will exhaust in the period of less than 10 years. Another 3 will last less than 20 years. 4 will get exhausted beyond 45 years. And 3 leases will have mine life beyond 50 years. No, but you must pay me from that 3rd year expiry for a closed, exhausted mine. Because I have a standard stipulation. Further, it is also informed that the production of commodity is driven by market demand, and mandating a certain production over a long period is not in line with the principles of mineral conservation, optimal use, and sustainable mining without taking into consideration market forces such as demand and supply of the business environment. It's an artificial superimposition, completely ad hoc by delegated legislation into real market. The rule of so-and-so 17 provides for modification in the approved mining plan as considered expedient, keeping in view change in business environment, that's the language of the section of the rule, or for facilitating increase in production, or in the interest of safe and scientific mining, conservation of minerals, protection of environment, or any other reason to be specified. It can be seen that the right of the lessee under 17 are impinged upon by Rule 12. Therefore, now they are coming to a conclusion. And this is the highest authority, a very competent, a very organized authority with experts and scientists. Therefore, based on the analysis made in the following, can be concluded. Stipulation of Rule 12A2 was introduced as a condition to ensure the raw material supply post expiry of. So, am I wrong? Am I false? Am I lying? This is very clear. This is what the contemporary expositor of the people who operated believe. And the production figures over the last 5 years clearly indicate that supply of iron ore is more than the domestic requirement. So how can you force me to sell? It's a distress sale. Just see, the excess in the market, the price has gone from 100 to 50. He says you're forced to sell. It's for the Lordship has a compulsory acquisition law and essential. Even their Lordship can't allow this easily to happen. He says you must go out and sell by delegated legislation. The annual production of previous lessee, whether over the entire period of the lease or any specific period, has not been defined in Rule 12A2, which creates confusion in defining the future production. So there is no guideline. I said so already. Further exploiting the mineral resources of the entire period of lease, as stipulated in 12A2, is not feasible if another stipulation of the same rule to maintain an annual production equal to or more than the production of previous lessee during the balance lease period is followed, as the reserves are getting exhausted well before the expiry of that lease. So what is the compulsory dispatch? Will I dispatch air? Or will I actually, not to sound absurd, I will buy a mineral from the market and dispatch from my mine? Because I have to comply with the environment requirement. On the other hand, to exploit the entire resources as per stipulation of Rule 12A2, the production needs to be ramped up to the unsustainable levels in few cases, which is contrary to optimal and sustainable mining and conservation of mineral along with protection of environment, intergenerational equity, distribution, etc. The Rule 12A also impinges upon the rights of the lessee, provided under 17, wherein a mining plan, including the proposals of production, can be modified at any point of time. In the light of the business environment, there is demand and supply. Therefore, the production should be driven by the demand created by market forces rather than speculation. This is not words, very serious. With deepest respect, you have no idea of how the market is going to be after 2 months. Here you are providing for 50 years. How which product will be, an airline will start using some new material or lesser material, will you do titanium, will you do aluminium? But it's a one-size-fits-all approach. It's completely a one-size-fits-all approach, and it's an absolute stipulation at great pain of crores of rupees on 5 charges. Last line, last paragraph. In the light of the representations given by the various mining companies, the analysis of the furnished above, the ministry may like to review 12A for addressing issues. It's not just a representation, it's a very careful statistical analysis by the apex regulator. Now come to the state of Orissa. letter of 2 April 2024. Because the last line is issued with the approval of the controller. Obviously, the IBM's controller approves this letter. I'll come to the next document. Well, this is quoted at page 24 of my note. Page 24 of my written service.
Where is that letter? In the original writ petition?
This letter,
The second one you are
the
referring
second one
is 2nd of April.
My rejoinder at page 41. I put it, but there also it is quoted. The full letter is not there. It is quoted, which is a fair quotation here also.
No, I understand.
So it's my pleading. I put it in the rejoinder. There also right on the side, page 41, which is my rejoinder to the Government of India's counter, which came in October 8th.
So where is the rejoinder?
Please give the rejoinder.
Rejoinder in which matter? Item number, there's a fifth matter.
Well, the also problem may be solved. Item 3, not in my file, but in item 3, it is at page 81. The full letter is there. That will be just seen for a while. Clear enough?
No, I just wanted here.
19172. The writ is 19172.
Page,
81.
just 1 minute.
Now, we are at your rejoinder.
Yes, sir.
No, we are, the rejoinder, I could get it.
Double two four three one.
There's a
22431.
Rejoinder is there. Which
Rejoinder.
page?
41.
What if?
Rejoinder to central government.
Letter dated 2/4/2024.
Correct. And Lord's will note on the side, just for reference, as the same letter and extends so is
Oh,
annexed.
that is also you have quoted. I just wanted, where is the?
Actual letter is item number 3, page 81. Your Lordship will use the file of item number 5.
Yes.
Please ask the courtmaster to get Lordship 19172. 19172. It's in the whole letter is annexed. At page 81. Annexure 44,
Rejoinder.
rejoinder of that file, that item 3 file.
Yes.
It's annexure 44.
Yes.
May I read it once?
Yes.
2 April, from Mallas Additional Secretary to Government of Orissa to Joint Secretary of Government of India. Verification on fixing of annual production and dispatch target under MBP 3rd year operation onwards, which means Mallas up to 50. See the first paragraph. The operation of a mine is supposed to follow a mine design, which allows exploitation of the reserves in a safe, economic, and environmentally responsible manner, reflecting the unique characteristics of the deposit, anticipated market for the product, and the profit expectation for the market. Very fair summary. Such a design is translated into the mining plan, outlining the operational, financial, and environmental objectives of a mine, and setting forth a plan of actions to achieve. It also provides a framework to measure progress with success. I think it's a very well put set of words in para 1, subject to my law's discretion. Then you also skip the next few paras. Then what will come through? 5. Continuing to the level of production in mind is critical for ensuring a steady supply. Don't let us eat all the golden gooses on the first day. Then skip the rest of the rules are there. And come to para 8. 8 sites, 8 beamers. 8 mandates that all valid rights shall continue. I'll skip that.
Yes.
9. However, Rule 12A2 mandates the level of production from 3rd year onwards to be equal to or more than the annual production by the previous lessee, and further requires the new lessee to work out and implement an annual production plan. Thus, Rule 12A2 prescribes a restrictive plan for extraction of minerals from 3rd year of operation onwards, which may not conform to provisions of 13(12)(17) and Rule 35. These are those words of studied moderation. They are in effect saying that it is completely contradictory to their own set of rules. In para 11, I am interested in, but up to 11. Several new lessees have certain representations. One, the period in terms of the number of years for which the previous lessee's annual production is to be considered as the basis for fixing the target has not been very serious, whether it may sound small. Your lordship doesn't know the spike year because I am officer 1. He's officer 2, he takes the trough year. A third officer takes a middle year. A fourth officer takes an average. And the spike your lordship saw in the letter is very wide. The highest in 1 year is 65, 70, 80% more than the other year. Nothing is given. Then B, an annual production plan.
Sorry to interrupt this. Regenerate to the Tata or regenerate to the
Number 3. Item number 3. 19170. Ghanshyam Mishra. Ghanshyam Mishra.
Yes.
Given the gender.
No, they have extensively quoted in this matter also in their rejoinder at page 41, which I find. So I just wanted a full text
Full
of the letter that what it means.
An annual production plan ensuring full exploitation of the mineral resources in the period of lease may not work out to the annual production achieved by the previous lessee. How does my plan for the future match exactly what the other fellows does? It's absurd to think that it will happen. Technical difficulty in achieving the annual production of equal to or more than the annual production of the previous lessee by the previous lessee due to the operational modality as approved under the mining plan based on the mine specific limitation. Then whereas the question therefore arises as to whether the preparation and implementation of the scheme, etc., under all these restricted areas, and independent of Rule 12A, or by suitably harmonizing all the provisions as mentioned above. This is the real point, as one is made without reference to 10 other rules. 12A is made without reference to 10 other rules. It is therefore requested to kindly examine the matter and provide necessary clarification as to whether the state government is competent at its level to fix the annual production and dispatch target under MDPA for the new lessees of expired mines for the period from 3rd year onwards by suitably harmonizing the above seemingly contradictory provisions to ensure sustainable and scientific mining, at the same time keeping in view the adequacy of supply of minerals to the consuming industries and the interest regarding revenue generation for the state, subject to revision at an interval of 5 years or any other clarification as the ministry thinks fit, which can help the state. Whereas you have two governments talking, they cannot be rude to each other. But this is a counterpart of a petitioner calling it a seemingly contradictory. Polite words I use. Very clear. One is completely out of sync with the other. Please tell us what to do. We are the operators. We have no, that's the Article 14 point. Vagueness, well, it's contradictory, no guidelines how to operate, excessive delegation. That's Article 14. What else is Article 14? Now, there are a lot of judgments on this, but this one is important. At para D.5, page 25. Well, these are not abstract Latin phrases. These doctrines were evolved. Well, your worship has two interesting words, anti-Latin. Before we started fighting, because those people start fighting, then they don't speak the truth. Pre-fight, they speak the truth. Anti-lighter motor, post-lighter motor, etc., etc. Similarly, those who are well versed in the operation of a regime, their contemporaneous, the word is not contemporary, that is actually anti-lighter motor. Contemporary means anti-lighter motor.
True.
Will have a greater ring of truth and therefore by your lordship should be given greater weight. That's the doctrine. So let us look at the contemporaneous exposition. I have just given lordship directly on the point, two contemporaneous expositions. Now on that fact, on those two facts of the previous two paragraphs, this is the law. Deshbandhu Gupta. It may be stated that it was not disputed before us that these two documents, which came into existence almost simultaneously with the issuance of the notification, could be looked at for finding out the true intention of the government. True, kindly mark the word true intention. True intention. In issuing the notification in question, particularly in regard to the manner in which the outstanding transaction will be closely clear. The principle of contemporanea expositio, interpreting a statute or any other document by reference to the exposition it has received from contemporary authority. As simple as that. can be invoked through the same, though the same will not always be of decisive. Obviously, Your Lordship has a third letter, which is not decisive. Nobody is saying it is. It has been stated in Maxwell and Crawford, etc., that administrative construction, that is contemporaneous construction placed by administrative or executive officers charged with executing a statute, mark the word executing a statute, generally should be clearly wrong before it is overturned. Such a construction, commonly referred to as practical construction, although not controlling, is nevertheless entitled to considerable weight from any persuasive. All rules of construction are persuasive, nothing is binding. Next page. It is well settled that courts in construing a statute will give much weight to the interpretation put upon it at the time of its enactment, and since by those whose duty it has been to construe, execute and apply it. I do not say for a moment that such interpretation is controlling it. Your Lordship has the overall picture, obviously, Your Lordship will be the punishment. Now, this D.6 is very important for the all showing Your Lordship's perversity in the context of unreasonableness for the application of Article 4. Unless I show factual perversity, I don't make out booty. Last three paragraphs, D3, D4, D5, and now D6, all go towards that. Article 4. Manifestly arbitrary, patently unreasonable, completely vague, and incapable of operational efficacy. That's my second reference. What should we got? D6. D6.
Yes, yes.
Manifestly arbitrary, patently unreasonable, completely vague, and why? Let us see one by one. Compulsory dispatch indefinitely for 48 years on a collective basis from all mine holders. There are 334 in this batch alone, in terms of that particular category, would create huge irreversible distortions in the market. For example, it would convert a free market system which seeks to find its own price equilibrium into an artificial ecosystem akin to a buyer's market, since buyers collectively and individually, knowing the legal compulsions and desperations of a seller to sell, will be able to dictate terms including price. Sellers individually and collectively would have to deal with the minerals mined and produced in a mechanical manner, beholds market realities. Since they are compelled to dispatch and sell at a minimum quantum, they would be unable to wait for a better price. It's obvious, common sense. They'd be unable to plan long-term sustainable extraction and exploitation in the mine. For example, by extracting smaller reasonable quantum each year, to spread it over the life of a mine, since they will be under compulsion to extract and sell a minimum number. Such compulsion to extract and sell a minimum number each year would also lead to ecological distortions and exploitation of a natural resource, contrary to established principles of mineral conservation, intergenerational equity, sustainable mining, care and caution against overexploitation. Clearly, a compulsory extraction, dispatch, and sale would shorten significantly the life of the lease and the life of the mine, which is intended to be utilized in a gradual and phased-wise manner over the life of the lease period. A period is wrong, but the lease period is right word. Consequently, also manifest arbitrariness. Now, as I have given in D7, which I will not read, is very just take D7, the first and the last clause. Each is the individual ground. Each is individual ground.
Yes.
This provision is vague. There is also have severability from pre-Balsara to Chamarbawala. The two most famous cases of severability in the 50s were Balsara and Chamarbawala. It is one of the ironic diagrams for 50 seconds that Chamarbawala is so famous in our jurisprudence for a point which is actually peripheral. For 70 years, it became famous for severability. In the last 10 years, since I am doing all those cases, dummy as a game of skill, etc. Chamarbawala is cited for the real issue decided, namely games of skill versus games of chance. All these years, we never used to cite for this so much, it's always of severability, which is actually a relatively minor part of it. The real issue, Chamarbawala, is game of skill versus game of chance, which now for the last 10 years, in all the High Court judgments, 5 High Courts across the country, have well as upheld this distinction, relying on Chamarbawala. Then was E, the penultimate ground of unconstitutional. Now this is disproportionality. Now really this will go along with the previous D3, D4, D5, D6. The facts are the same, but just another facet to it. A catena of judicial precedents establishes beyond doubt that the vice of disproportionality is hit by 14. Disproportionality has been elevated and subsumed as a vital component of the 14 itself. Read E2, E1 and E2 together. Madam. These are well known. Madam. In this
No difficulty.
author has been Justice Sinha. There are many more, but there's only one I've given, Shri Kumar Roy. And what else? This hits not only legislation, it hits subordinate legislation also. Is the next statement. Lordship don't want to read this discovery. You should know the law of the ones. E3. The Honorable Supreme Court in a catena of judgments balancing test and the necessities as disproportionality issue. Dismiss says that proportionality involves balancing test and necessity, whereas the former balancing test permits scrutiny of excessive onerous penalties or infringement of rights or interests and a manifest imbalance of relevant considerations. The latter necessity test requires infringement of human rights to the least restrictive alternative. Applying this is most important. On E.4 is the counterpart of D3, D4, D5, D6. E.5 is very, 4 is very important. E.4 and E.5 both are going to be slow on this, very important. Ex facia, it is was disproportionate. Ex facia. On the one hand, there is no mandate whatsoever textually in the main sections providing for the concept of compulsory dispatch. See para A1 to A10 above. Assuming without considering that rules could bring in this concept without statutory sanction, at the highest, it could not exceed the initial period of 2 years. Despite the aforesaid absence of authority, 12A in general and 12A2 in particular goes to the other extreme and authorizes the levy of as many as 5 disproportionate, oppressive, and severely prejudicial charges on the value difference of what the lessee actually dispatched, as opposed to the minimum compulsory dispatch requirement purportedly. Value difference, not on what is actually dispatched, but the difference between actually dispatched.
This is what I find.
Yes, there is a value difference. The word difference is.
Yes.
Yeah. These 5 charges calculate on the difference between the compulsory minimum and the actual dispatch are 1 royalty, 2 DMF, 3 NFBT, 4 bid premium, and 5 performance security appropriate. Now see why it is backbreaking. C6, small Roman 6. 2023-24 period, 0.6 is the limit by the mining plan, and
1.36 is the dispatch.
That's clearly more than double, above double. Notional dispatch would be for that unit 7,60,000 tons. As per the ASP published, the multiplier will make it 1,400 crores. So till now there's no problem. This is the main figure. Now comes the levies. So not compulsory non-dispatch, or rather compulsory dispatch not done, is worth 1,414 crores. Now on this 15% as royalty is the first charge, that is 212 crores. 10% is the second charge on this first charge, which is 21 crores, 21.21 crores.
Then 2% of the full amount.
2%, there's a typo there, is the word second charge, it should be third charge in the second line. 2% of the deficit is the NMET, is the third, the word second is the wrong word. Third charge. Then 93% of the full amount of alleged deficit would be the bid premium. Now this figure is 1325 crores. Because we are not talking of, I mean, this is all right, you can say it's a big company, this is not the way to us. This is the 19 when G goes out of the window, Article 14 goes out of the window, everything is directly involved. You are not here for charity, Mills, I'm doing some business. 93% is 1325 crores. This is only 1 year, 23-24. And on this, fellows, is performance, top of all this, is performance security of 339 crores. The grand total is 1902 in the last but one line. This, if it is not disproportionate, I'm asking myself what can be. and there is no statutory direct sanction. There is an implied sanction worked out from 12(1)(a), but this is going beyond in 12(a)(2) for 40 or 50 years. Now, this is a doubling, which my lord appreciated when I opened the open. That is E.5. Indeed, there have been further absurd consequences by the application of the aforesaid perverse principle. In the year 2021, I produced from the mine 1.36, but did not dispatch because of adverse market conditions. In that year, under the impugned rule, a demand of 613 crore for alleged non-dispatch was raised, which included all the 5 components. In the immediate following year, which is 21-22, in view of the improved market conditions, a part of this quantum along with other dispatches was made. Now, this is important on the 4. The nature of the regime is such for removal and dispatch requires a necessary application by the petitioner for issuance of a transit permit from the state, without which minerals cannot be removed, without prepayment of the charges specified above. It's a prepayment first, not afterwards. Consequently, for this removal in the next year, that is 21-22, is the doubling. I again had to pay the aggregate of all charges. Well, I'm sorry, there should not be a gap there. 129 crores.
Is there 129 crores approximately?
129. So, Malab, this is for nothing. It's the same mineral exported next year. Notional not given this year. The same mineral next year. And second time I pay 129 crores. It's literally making money out of air. Then was last head of constitutionality. Rule 12(a) as a whole, and Rule 12(a)(2) in particular, also directly violates something by creating 2 separate artificial classes of greenfield and brownfield. I understand there's a distinction, but at the end of the day, when you're talking of 1,300 crores, 1,900 crores, then kindly just bear in mind. I know your lordship is right that one is greenfield and brown, the 2 are different classes. No problem, that's not the argument. The 2 different classes can be kept different for 2 years. They can be kept different for 3 years. They may be kept different for 5 years. Reasonableness is a point. It's an arbitrary line. We all understand. You have to draw an arbitrary line. There is no fixed cost. Can't be 50 years, brothers. Why should a greenfield and a brownfield be 50 years distinction? You are setting a reset button. I understand that you are virgin greenfield, I am brownfield. So what? After the reset button, or maybe 2 years more after that, for the entire lifetime, I am competing with him. Imagine, I am competing with him. He is not paying 20 crores, 1920 crores 1 year if he's the same size as me. How can we both compete?
But the difficulty is to only visualize a situation. When we talk about the classification clause being a discriminatory in nature, what you are trying to say is that there is already an existing mine, operational, functional, by virtue of this particular auction regime having been brought subsequently. Now somebody has participated by submitting the bid. He is awarded the lease. So once he is awarded the lease, there is a period of 2 years which we can consider
It's a window.
is a window that has been provided, which is not provided in a greenfield. That's a distinction that comes. Now, once the successful bidder comes, what would be the duration of the lease? The lease would be of 50 years.
For both. For both.
I'm telling you, 50 years. Though this particular mine was operational since last 10 years or more, or for 1 year or 2 years, it may be. It all depends. So there is already a existing mine. There is already a mine which is functional. Now, in that event, 50 years gap is given. Similarly, when a greenfield mines are there, this is for the first time they have to make it. So for 50 years, they have been given. So we can definitely find a distinction in between these two.
So well, I will start with this.
So
I bow down. I must. My lord, if justice is formidable, I cannot be unreasonable. I can start with that the 2 are not identical. Therefore, there is a reasonable classification. So let us start against my point. My lord is absolutely right, and I cannot be unreasonable. So I start against myself that the classification is valid. Well, is at the highest the classification is valid for the first 2 years. It may be valid on an ad hoc basis for 2 more years. There is no possible reason how it can be valid for 50 years. Today, this argument doesn't go to the first argument of permanently Article 14 for the whole. It's only on 19A2. Sorry, 12A2. This argument I'm now making is only on 12A2. That it expands this invidious distinction. It expands this invidious classification beyond any reasonable what is the object which your Lordship reasonably wants to achieve? Your Lordship wants to achieve just seamless transfer, no diminution in supply, no disruption in supply. How is it achieved? By continuing this invidious distinction for 50 years? So therefore, the classification of the test is a dual cumulative test. It is not.
Why
enough to have a valid classification.
Why not? There will be a distinction because is somebody who enters into the field for the first time and somebody who enters into the, sorry, I stand corrected. Somebody enters into the field for the first time in an existing one, then he has to start from something, I would say the scratch, because the earlier lessee will take all his, the equipments from there. They will definitely not permit you to utilize. So 2-year period, so to just, I would say, is a window or is I would say the breathing time, which is also given. And also to ensure the seamless supply of so that's there. And he will then continue to operate 50 years. Here, he will also operate for 50 years. Then why not the distinction?
The entry point is different.
True.
The continuance of 12A2 regime.
True.
After the entry point, indefinitely for 50 years is not. It is Article 14.
That is, you say rationality on the ground that there is no reasonability.
My Lord may not think that my argument is that there is no valid classification. Obviously, there is even I am making a classification between greenfield and brownfield. But the test of 14 is a cumulative one, not a single test.
True.
It is not a test of classification. It is to show the object sought to be achieved. Now, one thing, Lordship may note, the outgoing lessee takes his equipment with him. There is no transfer of equipment. It's only the transfer of the lease.
True.
So the equipment doesn't remain, it goes
Definitely.
Now, the new person will operate it and may need something for which you are punishing him that he should not stop. Actually, that itself is a flawed assumption, but I'm not going into that. To think that I will take over and sit on it and keep quiet may not be there, but they may have found diminution. So it's fair enough. I'm not questioning. And now only 12A2. The larger ultra vires is about compulsory dispatch.
No, that is a different issue.
So now he has a reason. Nobody is going to bid in an auction. Also consider this. Somebody who bids in an auction has spent a lot of money. He will be an utter fool to not dispatch after the initial pleading trouble, as the Lordship puts it.
That's a commercial wisdom.
Unless somebody has got some very long-term plan in the 48th year, I will have a jackpot. He's not going to sit quiet for all this time. So, the very concept of the greenfield guy merrily operating in the 4th, 5th year, there is a complete convergence. But make it more stark. Take 2 identical minerals. Take them at a distance of 1 kilometer apart.
True.
It becomes stark. And the amounts are very large, Willis. It's a crippling. If it is difference, nobody will. This will cripple this chap. It will not touch it. By the accident of how I bid the historical point of time, which is over for 2 years. And I'm prepared to say no, that some leeway can be given. But it can't be a 50-year period. That cannot be, because 50 years is the length of the entire lease. That's the point. So to put it in Article 14 terms, while the classification is understandable, there is no rational nexus with the object sought to be achieved presented to your Lordship. None is presented to your Lordship, except saying that one is greenfield, one is brownfield. Of course, we know that. My lord put it nicely when he said after 2 years, greenfield also becomes brownfield.
Provided it is
So,
re-auctioned.
Only after 5 years.
Then provided it is re-auctioned.
But it is no, but that is different. I'm saying the nature of my identity with his identity.
I understand that after the gap of certain periods, there's
birthmarks are different.
True.
But post-birth, our continuance and existence is identical. We are the same member, we are doing the same activities. We have the same MLDR. So birthmark of historical nature is not going to affect this.
Yes.
I just read F5 and F7. My Lord understood the point I'm making. Those F5 and F6 for a minute. I'll skip the rest.
Yes.
12A2, which is the scope of operations, creates an oppressive regime only for brownfield leases for years 3 to 50. Life of such leases has the effect of treating legal the unfilled. Indeed, the Parent Act makes no distinction. Now, this is important. Parent Act does not make a distinction between greenfield and brownfield options.
Yes.
Parent Act did not bring this thing. Only 12A brought it.
Correct.
So there is no distinction at that time. Yet the oppressive and prejudicial regime of Rule 12A2 applies similarly only to the category of brownfield. There is no rational nexus. By way of example, greenfield or virgin leases are under no obligation under any rule to compulsorily dispatch members of the entire. It was a very, very big bonanza. Not a small thing. While assuming without considering there may be a distinction for such leases, etc. Such distinction would dissipate after 2 years. I made the point I was reading it. Same point. Now this thing about overriding the LDP. And therefore I am being asked to do the impossible. The present 4.1.
Yes, yes.
4.1, sorry. The present case concerns 4th year of the mining lease, that is period from 23 to 24. That's the writ Your Lordship is seeing. The state is enforcing a dispatch requirement of 1360, whereas the modified plan makes it only 0.6 from the 4th year onwards, being 80% of 0.6. The entire analysis above shall be read. The grievance of the petitioner stems from the fact that during the relevant year, that is the 4th year, the petitioner was operating under a validly approved mining plan, 22 July, which restricted annual production to a maximum of 0.6. The upper limit was approved. This is the question I not asking. Maximum. The upper limit was approved by the IBM pursuant to the petitioner's application which had been filed following consultation statement. On receipt of the modified plan, the petitioner informed the state authority the same who took cognizance. Despite this, the impugned demand erroneously proceeded on the assumption that the petitioner was obligated to maintain a production level of 1.7 and the dispatch target of 1.3 without recognizing the superseding effect of the modified mining plan into finding under 5.2. That's the legal point. Very, very important. 5.2b makes this prevail, and you can't go over again. It is undisputed that for the entirety of the 4th year, the petitioner's production was capped at 0.6. The next page, page 32. It is further pertinent to point out that clause 10 itself requires the petitioner to comply with the manual plan of all. Now, as clause 10 of the agreement is a nuance. You are saying that the agreement may trump the plan. On the contrary, I read clause 10 to your Lordship of the agreement, which say that you should comply at all times with the mining plan. That's para 4.6. Thus, the impure order effectively requires the petitioner to violate the MDP itself. It is well settled that law cannot compel the performance of an obligation which is impossible. In fact, the mining plan operates with a statutory injunction to production limits, the maximum. And thus, there can be no agreement to produce beyond the limits imposed by the mining plan. Axiomatically, since the petitioner cannot produce beyond the limits specified by the plan, the corresponding dispatch requirements must also be limited to 80% of that limit. So if they say 0.6, 80%, I'm not saying that's the right thing, subject to all my other arguments, but the compulsory dispatch can't be more than 80% of what they permit. Law cannot compel performance of an obligation which is impossible. And statutory injunctions can be granted to constitute an impossible obligation. Can be a ground to constitute an impossible. The second one is important one. If I have a statutory obligation, then it is a statutory obligation. Then is natural justice. The letters are 4.8, ignore it. So the 2 letters my Lord solved me. Now, this is a very neat ground by itself at page 32 bottom and 33 top. It's a very neat and simple ground. I repeat, your Lordship is entitled to something like this ground. Not that I am asking your Lordship to do it from this ground.
Yes.
The impugned demand of 3rd of July, that's the only impugned document, has been issued in violation of basic principle of administrative fairness and natural justice. Neither was the demand notice preceded by any show cause. Well, according to us, whatever you call it, there has to be a distinction between a demand notice and a show cause. Conceptually, a demand notice is, come on, give me the money. That's not a show cause. There is no show cause here. That's point one. As a matter of fact, the petitioner earlier received demand notice of 7th of January. Now I'm arguing this for a minute, assuming that the 7th of January is some kind of a show cause, which is wrong. It is not so. Received demand notice for 7th of January, page 415, for the very same period, which too was not preceded by any show cause, seeking to deposit 1563 crores. The current one after to produce deposits 98 crores. The current one, the final demand of 3th July, asked us to deposit 1900 crores for the 4th year and 2400 crores for the 5th year. This one, at para 5.2, is in the same line, the original demand of 7th of January, which asks me to deposit for this 1563 crores. For the same period, which too was not preceded by any show cause seeking deposit. In response to the said demands, the petitioner made a detailed representation on 28th of January, that is within 2 weeks, and requested them to withdraw within 3 weeks. Shockingly, neither the opposite parties afford any specific show cause opportunity to the petitioner, nor afforded it any right of personal hearing. Instead, the opposite parties raised the revised demand of 3 July. Now, note for us, from 28th January to 3rd July, there is nothing. Nothing. Increasing the amount demanded from 1563, which is the figure in 28th January, to 1902, which is the figure on 3rd July. Particularly the said revised demand of 3rd July does not refer to or deal with any of my submission in my chart of in my representation of 20th January. Well, we have traveled far. Ginapani Day 1967. It could be very mildly any adverse civil consequence. There is no adverse civil consequence. It's a backbreaking consequence. Ginapani Day is the bottom of 33. But this Canara Bank is important because your lordship has completely caught faith, doesn't matter. And just see where you should apply the natural. My lords applied natural the privilege of assessing the court. In a fraud case, what suppose banks declare fraud. These are NPA. Bank declared that your account is fraud. So the argument by the solicitor and the attorney, in fact, fraud declaration is getting to a criminal declaration. We are going to complain to the police also. There is no question of natural justice. You are declaring this account to be fraud, which is beyond NPA. You already declared to be NPA earlier, for which you got some cause. And therefore, no natural justice is required. And the case I did was for respondents, SBI was the petitioner, involved thousands of crores in each case. The court read in natural justice even to the fraud declaration. By saying that though it is quasi-criminal, he must get an opportunity to demonstrate that this is not fraud. So was Canara Bank, Raghunath, that case is called SBI versus Agarwal. I'll add that later. It's not here. And the third set of cases is premeditation, empty formality. Oryx is the best one. Now just turn to the demand notice, so-called demand notice of 7th of January. Page 415. It's 415. 7th of January. Let's come to 435.
415 or
415 is the original.
Is
It
it?
got merged into 435.
Yes.
I think my lord is right. Let me go by the sequence. Please go to 415 first. Then I wrote a letter. Assessment, this is from the Office of Deputy Director of Mines. Right? 4th of January. Assessment of shortfall in district of Proman. Government of India. In writing a reference to your survey, I am to say that the government of Odisha, part of my letter under reference is communicated regarding assessment of shortfall. Now, whereas they simply assess the shortfall in the next few lines. According to the assessment with respect to your September, for the period of 4th year, with effect on 23rd July, it has been made to 7,60,000 MB. So they make assessment. Now, you are therefore requested to make deposit the said amount. You are therefore requested to make deposit the said amount of 1563. Now, I reply on 28th January. Just go to 28th January. That is a page verse 428.
What about 420?
424. Sorry,
NSA 55,
424. Sorry.
NSA
No.
55.
No, before
Page-
that comes my reply. To
No.
415, I reply at 430, 424. Now, whereas actually it's already a demand notice because they made an assessment of the quantum. There is already a violation in 7th of January. So 415 is already a violation. There is no proper show cause. But treating it as a show cause, I represent at page 424 against them. I hope I'm clear.
Yes, now I got it.
So 420.
No, there are other correspondences which drew my attention to it. So I was just looking from 420 onwards.
But this is a detailed representation by me saying, look, all that you are saying there is wrong. There is no such thing. And I don't go into the merits. I've given everything here.
Yes.
And this letter is detailed verse to the extent of 4-5 pages.
Till 434, 10 pages, 11.
34.
He has cited many judgments also of the common cause and all
It's a
everything.
quickly done thing I will read. Now you forget this, fellows. We need to have some hearings, some adjudication, something on the way. After this, nothing happens for 6 months. That's the real point. This is January 28th. The letter which is impugned in your lordship's writ petition today before this honorable court is well as the 3rd July. Turn to 3rd July was at 4:35, if my lord was seeing this.
Yes.
Ending in 2 or 3 minutes. That's all. I will not even read it. Let's see 435. It's a 2-paragraph letter saying revise assessment. You've done everything. Come on now. Over. How, when, where, which, what? Nothing.
So Annexure 1 gives them a comprehensive, the calculation. Is there?
How?
Oh.
Not the examples.
Yes, yes.
And there's no pretense of having called me, heard me, and said something. This is not the case. This is the how question. This is sufficient on the existing law for a
So you wanted to make a distinction between a how and why.
If.
Oh, if.
But then if it is leviable at all, I've raised so many objections. Well, I can understand it to dismiss it by reason order. Is this a reason order? My lord is reading at 435. My question to myself. Great respect. No. You have the power to dismiss it. Nobody saying you are bound by man, but this is I'm on the merits. I'm on the process. The process is completely skewed. And the judgments make this the straight graph. One other thing. Your lordship heard me on the mining plan and this. Your lordship briefly heard me on constitutionality also. But very briefly in the first hearing. Your lordship passed the following order. Give me that order. Interim order. Go out. That's answer. Any years meeting. Whereas 14th of August 2025.
Yes.
Double two. One.
Hmm.
14th August,
Hmm.
the petitioner has filed the instant writ petition. The Lordship heard it some length, well, then.
Hmm.
These grounds in a very, very synoptic sense were seen by law. The petitioner has filed the instant writ petition challenging the action by invoking the provisions contained in the Rule 12 order. Then, well, so 12A is not that you also considered it. According to the petitioner, 12A was introduced in the said rule, meaning not only the minimum production for the first 2 years, quantification was done for the third year. At the advent of its introduction into the statute, there was no concept of minimum dispatch at the time. Initial incorporation of said provision, virtue of a subsequent amendment inserted from 10th of June, was introduced, which imbibed within itself the concept of minimum dispatch to yourself. I was going to pass the just a stay, but he gave a reasoned order after hearing and appreciating the objections. Sub-rule 1B further posted in the event the lessee did not maintain the minimum dispatch, the state government will terminate such bids. We noticed from sub-rule 1A that at the time of incorporation, the annual production and the minimum dispatch was also contributed without any quantification, but subsequently the quantification was done by virtue of schedule D, where the average annual production of the preceding 2 years should be 170. Actually, in a very, very pithy ways, obviously it's an interim hearing. The Lordship has encapsulated the art of some allocation on constitutionality also. As indicated above, subsequent to the said introduction, the petitioner was facing inconvenience for undertaking open cast mining, for which the approach was made for modifying. Lordship remembers open cast and underground. It appears that the Indian Bureau of Mines approved the modified mining plan for the period so and so to so and so, 136, subsequently withdrawn. The demand notice is issued upon the petitioner, which is a subject matter of challenge in the instant writ petition. The challenge is made on multiple counts, including the violation of principle of natural justice. That's how it also comes to this now. There is no symmetry between the production and dispatch in terms of the aforesaid. That's my first argument, first head. Production, removal, dispatch. And such disparity have rendered the performance impossible. Rule 12A as alleged to have not only violated the provision but also is unconstitutional. Therefore, the petitioner seeks it to be declared ultra vires. Also assails the demand notice is without jurisdiction as it propagates a double levy. Actually, all the contention and centers also are there, my humble submission. The record would reveal that after the first notice was issued, the petitioner responded to the same, but without adverting to the issues raised, the impugned demand notice is issued by the authorities without dealing with the stand taken by the petitioner. This is the Lordship links up always the process of ratiocination, is what I should call it publicly. Ratiocination is the connecting link between the decision and the reasons for the decision. That process has to be there. That happens mainly by hearing somebody or discussing something. That is what the Lordship, I believe, was intending to say in that paragraph. 7. We notice a distinguishing fact in the instant case where the competent authority modified the mining plan much before the period for which the demand is given. This is separate, it doesn't matter either way. And the event the production is reduced, where the dispatch, which is much higher than the production, can act adversely to the interest of the miner. And therefore, we feel that the provisions which are challenged require deep consideration. We have been given to understand that the spate of litigation have come up still pending, that this be tagged. It appears from the stand taken before us that a prima facie case has been made out for the reason that the competent authority has modified the mining plan and reduced the statutory amount of production, whether in absence of any modification plan of clarification is qualified with this law. Same can withstand. We therefore restrain the opposite party from taking it. Right? This is inter parties. I am Tata. The department is the same. My lord hears it. Master lord. The next writ comes when your lordship was in just recently. When your lordship intended for the 5th year to hear it shortly, but made it clear in the presence of all that please don't take any coercive action. Whereas the lordship was there, I was there, my friend, the KG was there. The lordship said it not once but 3-4 times. Obviously, in the light of this order, having heard of it. Because the lordship doesn't have an inconsistency between division benches on the same issue. Anyway. Now, what is the only coercive step they have over me is that they will not allow clearances. They don't issue what is known as trading pass. That's it. Notice despite, now you come to my IA and I'm done with IA. Just tell the order for 6th November for a minute. Justice, Chief Justice, and Justice Raman's 6th November.
In which matter?
310.
The order is passed formally in 31035. 31035. On 6th of November.
Yes.
Identical issues are involved in the instant writ petition. Right? First sentence is very important. Where the parties are the same. Only the year is different. You all got it? Now, after my lords passed the order, data. In terms of the earlier order, this matter is taken up along with item 44. It is submitted by so and so, appearing with the petitioner, but the instant matter not only involves the issues which are identical, but disparity on factual metrics can also be seen as the authority in the
Paragraph 4, we recorded it.
Before para 4, but just give me a minute on para 2. Para 2. My laws recorded more brothers, but the disparity can be seen as the authority in the garb of alleged demand is contemplating to reject the trading license. Don't you got that? Now let us kindly leave 3, come to 4. That's why lordship recorded. We noted that in some other matter, the interim protection, no coercive taken has been passed. In some, there is no express recording. But all such matters are tagged to be taken up at one go. Now, brothers, my IA, which is there, it's a 1 minute IA, because formally, despite this, this is the problem when they, in good faith, we say, they have not allowed trading license to issue. Lordship was trading license piece of paper. Without that, I can't transfer. Because on the ground, the trading license is a pass, which says that I paid this national demand. So they don't issue that. And that's for the same year, the same parties was come to my IA, and I'll done in 2 minutes. IA 20440. In the item number today,
Flag
1. And I don't need to file the IA. I told you, Lordship, I was standing here, my lens was standing here. It's not, it's a good faith gentleman's agreement.
Yes. B. Oh, first one. Okay.
Flag B. B in what? Flag
Yes,
B
yes.
is the first item.
Yes, yes.
Well, with respect, so no need for this. But because you are driving it to the wall, huge amounts are involved. Just see this, brief grounds. Trading license, and I told your lordship that day it's about to expire on 30th October. That's why we were concerned. Without trading license, no mineral can be supplied to sponge iron plant. Now this is a collateral damage. How on earth does the state get help? I am a sponge iron plant. All the people earn employment and money. I will starve. It's like saying you will have a man without food, who hungry, resulting in shutdown of the plant. Renewal application we are for July. DDM showing pendency of the 5th year demand. This is a subject matter of lordship's writ. Despite oral assurance, my trading license still not being processed. Daily loss of 1.39 crores due to shutdown. This is not fair, brother, with deepest respect and humility. It's not fair. Cut your nose to spite your face. How did this practice been continuing all along? Your lordship are hearing it today, brothers. Each day, one of these buses go, these trucks go.
Yes.
This, your lordship may clarify, unequivocally, because I'm not inclined to accept any statement by them, brothers, because this is what the result of a statement is. And this is completely equitable. We are all acting in good faith. And I said, I don't mind if my statement is made clearly. After the statement, why should they stop my trucks? Well, the trading pass can't be formally given because the lordship is hearing the demand of the 5th year. That means like my trucks can't go to feed my sponge iron plant at 1.39 crores per day loss. It's just there is a screw on me. I'm deeply obliged. That is all that I am. Very deeply obliged.
Thank you.
So, lordship will consider clarifying this by the end. Deeply obliged. To excuse my absence for a few minutes.
Oh, yes.
I appear in items 2 and 5, workshops both. May I request, Lord, that the paper book of item 5 would be kept by your lordship side.
Which one? The same one,
Lord, CWP number,
22431.
well, that is 5215 of 2025. That is the repetition in item 5. It's by the same repetition. It's what item 2.
Which one?
By 215.
Oh, no, 133.
He is addressing one two.
No, Nabira power is 16665.
No, he is addressing 5215.
Yes, that is repetition number
Which is 52.
5215 of 2025.
Yes,
I'm great.
yes.
Now, Lord, your lordship may just keep the paper book because I first will not deal with the point in law. Well, Lord, in my case, well, Lord, the point of virus is not a very compelling. I'm not necessarily driven to argue the point because in the facts of my case, well, Lord, even if the rules stood as they did, the demand, my Lord, is contrary to the rule. But I'll come to that point, my Lord, a little later because your lordships want to hear us on the question of the construction of Rule 12A of the rules. Well, Lord, first of all, my Lord, the real point for consideration is what does the Act, the rules, and the agreement insist upon? They insist upon what is called production. And the concept of dispatch, my Lord, is distinct from the word production. But production which is ready for dispatch is only, my Lord, to emphasize that in case there is demand, you are in a position to meet the demand. But it is not the same thing as a compulsory obligation to dispatch. This is, my Lord, the point which I want to address your lordships on. And this, my Lord, is actually fortified by the provisions of the Act, the amendments which have been introduced in the Act, and also, my Lord, the rules which were framed, including the mineral auction rules, under which, my Lord, these auctions have taken place. My Lord, I must tell your lordships that everyone who is a bidder is in fact, my Lord, a new lessee. Everyone, my Lord, whether it is brownfield or greenfield, he is termed as a new lessee because he has secured the lease only by virtue of the auction. Now, Lord, let me take your lordships to a few provisions of the Act because it's necessary to see what is the context of Rule 12A. Once your lordship sees that, Lord, it will be crystal clear. Lord, may I request your lordships to take the Act with me for a moment?
Yes.
Lord, please see in Section 3 of the Act,
Yes.
my Lord, this expression dispatch to a, that is 3AA.
Which I was saying, the removal is synonym of remove. These.
My Lord, was inserted.
We need to.
In Section 3AA,
Yes.
this word dispatch is defined. Your lordship notices that. This, my Lord, was inserted for the first time by Act 16 of 2021. That is, my Lord, 28th of March 2021. That's, my Lord, clear. So, my Lord, this concept of dispatch is independent of production. Dispatch means the removal of minerals or mineral products from the leased area and includes the consumption of minerals and mineral products within such leased area. Then please, my Lord, see 2D. Mining operation means any operation undertaken for the purpose of winning any mineral. And then, my Lord, please see FA. And FA again, my Lord, is inserted on 28 March 2021. This FA is production. So, my Lord, production is now defined like this. Production or any derivative of the word production means the winning or raising of minerals within the leased area for the purpose of processing or dispatch. So, my Lord, this concept comes in only on the 28th of March 2021. Now, my lord, after this, let us go to section 4B of the Act. 4B. My lord, section 4B was inserted by the 2020 amendment. If your lordship sees 4B.
10 January, 10 January.
That's right, my lord, that's right. Please see now, my lord, 4B, conditions for efficiency in production. Your lordship see the word now very clearly. It uses the word production. Now,
both the words are differently.
that's right. That's right. Production and dispatch, my lord, are used distinctively in the Act. So when, my lord, the legislature intends to use both of them together, production and dispatch, it uses it. I'll show your lordship straight away. I'm very grateful to my lord, Justice Raman. Please see, my lord, section 4, capital A. I'm straight away demonstrating, my lord, where the legislature intended, it could clearly do it in express words. Please see, well, this was again on 28 March 2021, this amendment. Please see for a moment subsection 4, 4A4, where the holder of a mining lease fails to undertake production and dispatch for a period of 2 years after the date of execution of the lease, or having commenced production and dispatch has discontinued the same for a period of 2 years, the lease shall lapse in the expiry of the period of 2 years from the date of execution of the lease, or as the case may be, discontinuance of the production and dispatch. So, my lord, the legislature was clear that where it wanted to use
This particular, the production and the dispatch sees the light of the day by virtue of the same amendment by
Exactly.
which the definition of a production and the dispatch was incorporated into a definition.
That's right.
provision.
And, my lord, when the legislature intended to use it, it used it only in respect of termination. That is, if you don't actually produce or dispatch for 2 years, then you're liable to termination. My lord, it's in that context. Now let's come to 4B, my lord, in contrast. In 4B, please see, conditions for efficiency in production. And again, my lord, this is the original provision of 2020, as your lordship has seen. This 4B was inserted on 13th March with effect from 10 January 2020. Your lordships have seen that. Now, please see, my lord, 4B. Notwithstanding anything contained in section 4A, the central government may, in the interest of maintaining sustained production of minerals in the country, prescribe such conditions as may be necessary for commencement and continuation of production by the holders of mining leases who have acquired rights, approvals, clearances, and the like under Section 8. So, my lord, your lordships notice the word is production, not the word dispatch in 4B. Now, my lord, let us look at 8B. Because, my lord, 8B, that period of 2 years was ephemeral because it's been amended, my lord, since then. Please come to 8. My lord, if your lordship sees the footnote in the book, that shows, my lord, the unamended 8B, which had that period of 2 years, which your lordship's which my learned friend referred to. Please see, my lord, 8B2 provides, provided that, that's, my lord, the unamended at the bottom of the page, that subject to such conditions as may be prescribed, such new lessee shall apply and obtain all necessary rights, approvals, clearances, licenses, and the like, within a period of 2 years from the date of the grant of new lease. Your lordship see that's proviso at the bottom of the page in the book. That's the unamended section. Footnote. In the footnote, my lord, footnote 2. Oh, I'm so sorry. May I just hand over copies of the book? Please, just hand over copies of this book, which is, my lord, all the rules and the act in one place. If I may just hand over the Give to the, please give it.
It does not contain. That's why he's saying unamended is not there.
That's right, my lord. Otherwise, we will not get the correct picture with reference to it. My lord, this would be Well, this is in the Act, Section 8B. It might be page 12, my lord, in your lordship's book, I'm given to understand.
Yes.
8B.
Yes.
Does your lordship see there's a footnote too?
Yes.
This is, my lord, substituted by Act 16. Prior to substitution, Section 8B reads as under.
True.
And your lordship says, now please see 8B1. The provisions of this section should apply to minerals other than the minerals specified in Part A and Part B of the first schedule. Notwithstanding anything contained in this Act or in any other law for the time being in force, the successful bidder of mining leases expiring under the provisions of subsections 5 and 6 of Section 8A and selected through auction as per the procedure provided under this Act and the rules made thereunder shall be deemed to have acquired all valid rights, approvals, clearances, licenses, and the like vested with the previous lessee for a period of 2 years. And then the proviso said, provided that subject to such conditions as may be prescribed, such new lessee shall apply and obtain all necessary rights, approvals, clearances, licenses, and the like within a period of 2 years from the date.
So
of
this is also retained in the amended provision.
Yes,
also.
the amended, my lord, this is gone. So now,
No, he has to apply. I was just reading somewhere.
no, my lord, that is why please.
Within 2 years, he has to apply.
Please now come to the amended, my lord, that is by Act 16 of 2021. If your lordship sees on that same page, your lordships will find, notwithstanding anything so and so shall continue to be valid even after the expiry of termination of lease, and such rights so and so shall be transferred to and vested subject to conditions provided under such laws in the successful bidder of the mining lease selected through auction under this Act. Now, my lord, he does not have to get fresh clearances. He is able to run on the pre-existing clearances. My lord, now that period of 2 years or the obligation to apply under the proviso which your lordship saw,
That
actually goes. And now, please,
so
my lord,
according to you, once there was a specific provision relating to an obligation on the part of the new lessee to apply within a period of 3 years, the amended provisions conspicuously deleted that.
Exactly.
So in that event, by virtue of a rule, you cannot revive it.
That's right.
And this is what you.
Yes, and now please see, my lord, two with me. Notwithstanding anything contained in any other law, for the time being in force, it shall be lawful for the new lessee to continue mining operations on the land till expiry or termination of mining lease granted to it, in which mining operations were being carried out by the previous lessee. Your lordships now see this language. So it is clear that the pre-existing approvals, my lord, will continue. Now, after 8B, my lord, let us, my lord, the point in with reference to section 9, 9B, 9C, Dr. Singhvi has made, it contemplates removal. But I will come to it a little later. Now, my lord, please come to section 13, my lord, for a moment. 13 for a moment, which is at page 26 of your lordship's book.
Yes.
Power of central government to make rules in respect of minerals. And your lordships will notice that the title itself, Rules for Regulating the Grant of Mineral Concessions, was substituted, my lord, for a title in footnote 5, which was Rules for Regulating the Grant of Prospecting Licenses and Mining Leases. That was, my lord, in 2023, that is 17th August 2023. Now, my lord, please come to 13.2, the insertion of AA. We are now, my lord, concerned with this provision. And for testing the vires, my lord, of Rule 12A, your lordships need to consider 13.2AA. That is, in particular, and without prejudice to the generality of the foregoing part, Such rules may provide for all or any of the following matters, namely, AA, the conditions as may be necessary for commencement and continuation of production by the holders of mining leases under 4. So, my lord, it is only for commencement and continuation of production by the holders of mining leases. Now, this 12A, now, my lord, we are looking at the virus and the scheme of this 12A and the subsequent amendments. If your lordships now take 12A with me for a moment, let's look at, my lord, rule 12A. Because the virus, my lord, has to be tested with reference to the rule-making power and the object of the act. My lord, if your lordship sees for a moment, my lord, 12AA, your lordships will find it, my lord, at page 572 of your lordships. My lord, 12A1 was there since 2020, 20th March 2020.
Page.
Page, my lord, 570 of your lordships.
Yes.
Now, please see, my lord, 12A. 12A came into the, my lord, in the rules for the first time on 20th March 2012. And let us now read, my lord, 12A, the title. Additional conditions for commencement and continuation of production as per section 4B of the Act.
Yes.
So, my lord, the virus has to be tested with reference to 4B.
True.
And now, please see, my lord, the first, 12A1 with me. The first.
Yes.
Notwithstanding anything contained in these rules, during the first 2 years from the date of execution of new lease, the holder of mining lease, to whom the order of vesting of rights, approvals, clearances, licenses, and the like have been issued under Section 8B of the Act, shall maintain such level of production, please, such level of production, so as to ensure minimum dispatch of 80% of the average of the annual production of 2 immediately preceding years on pro rata basis, failing which appropriate actions in accordance with the mine and development and production agreement shall be initiated. Now, my lord, there are 2 ways to read this rule, this 12A1. If 12A1 is read as that the emphasis on maintaining such level of production, but this level of production has to be maintained, that in case there is a demand, you are in a position to ensure dispatch. Then, my lord, you are reading down the rule. But if this rule is to be read, my lord, as the state government wants to read it, as imposing a mandatory condition of dispatch under 12A1, it becomes ultra-virus. It goes outside the ambit of 4B. That is the point. My lord, we're looking at ultra-virus. Other parts, my lord, of unconstitutionality are different. But when we are testing the vires of a rule, we just have to see the parent statute and see whether it authorizes that particular rule. And that is, my lord, the test. Now, please see this, my lord. So therefore, my lord, there are 2 interpretations possible. If we want to save it from ultra-virus, we will have to read down the rule to mean that this condition of ensuring minimum dispatch of 80% is not a compulsory obligation, but is only a state of readiness that in case of demand, you are in a position to supply this 80%. That, my lord, is a fair way of reading the rule. Now, my lord, why am I saying this? Because your lordships will find that the only condition which is mentioned here is appropriate action in accordance with the mine development and production agreement. Your lordships have seen that. Now, my lord, the mine development and production agreement is only concentrating on a default in the levels of production. This mine development agreement, my lord, is only about default or a shortfall in production. And therefore, my lord, this rule 12A1 is meant to be read as not a compulsory obligation of dispatch. But my lord, when the rule-making authority wanted to say that it must be a compulsory obligation, failing which adverse consequences will flow, is 1A. What my lord, the Chief Justice pointed before the midday recess to me is 1A. My lord, that has been inserted from 1st of July 2021. That is 1A. And 1A says, in case of shortfall in dispatch from the minimum dispatch required under sub-rule 1, actually, my lord, this minimum dispatch is not
Makes it
really
imperative.
correct. It is, my lord, not really contemplated under sub-rule 1. There is no concept of minimum dispatch under sub-rule 1. That is why this, my lord, leads to an illusion. Minimum dispatch required, which shall be assessed on a quarterly basis. Now, my lord, please see the next few words with me. These are critical. The lessee shall, in addition to the amounts payable under Rule 13 of the Mineral Auction Rules 2015, for the actual dispatch, also pay to the state government an amount equal to the difference between the following. Now, please see, my lord, A and B. The amounts payable under Rule 13 of the auction rules for the quantity equal to the minimum dispatch required under sub-rule 1 in the said quarter on the basis of the weighted average of grade of minerals dispatched during the quarter, and the amounts paid under Rule 13 for the quantity actually dispatched in the said quarter. Well, please mark this. So it is A minus B, which has to be paid as a penalty in case there is a failure to dispatch under this Rule 1A. And your lordships notice the critical words in B are amounts paid under Rule 13 for the quantity actually dispatched in the said quarter. So, my lord, when these bids took place under the mineral auction rules, the bids were offered by the prospective bidders on the basis of a percentage which would be payable on the sale of the mineral upon removal, that is, upon dispatch. So, my lord, what this Rule 12A1A does is that instead of levying what the obligation is, my lord, to pay that 90.90%, whatever is that percentage offered by a bidder on that sale price, is upon dispatch. They are now converting, my lord, what should be payable on dispatch as if it can be treated as notional. That is, I will now treat you that you are under an obligation to have dispatched. If you have not physically dispatched it, I will charge you nevertheless. I will charge you nevertheless as if you have dispatched under Rule 13, of the auction rules. Well, that is a clear transgression. It is way beyond 4B. This cannot be justified under 4B at all, under any stretch of imagination. Neither, my lord, can 12A1 be read that way, nor can 1A be read that way. And now, please also, my lord, read with me. Please come to 1B, your lordships have seen, 1B, and please see 1C. 1B says, where the lessee does not maintain minimum dispatch required under sub-rule 1 for the year as a whole, the state government may terminate such lease after giving the lessee a reasonable opportunity of being heard. And 1C, in cases where the mining lease is executed on or before the commencement of the Mineral Rules 2021, that's, my lord, the July 2021 rules, the provisions of sub-rules 1A and 1B shall apply after a period of 1 year from the date of such execution of mineral lease or the date of commencement of the mineral other than atomic and hydrocarbons energy Minerals Concession Rules 2021, whichever is later. So, my lord, this actually postpones the application of even these rules of 1A until, my lord, that period expires. That is 1 year from the commencement of the lease, from the date of the execution of the lease, or the date of commencement of these rules, whichever is later. Now, my lord, in my case, as I said, mine is a straightforward case because, my lord, the first year is excluded. In my case, my lord, the demand notice is for the first year. Contrary to this rule, even if I go by this rule, it has to fall. But I'm arguing, my lord, the point that when your lordship sees 12A1, there is no concept of minimum dispatch. And my lord, it is clearly beyond 4B. And 12A1A is also, my lord, beyond 4B. 12A1B is again, my lord, beyond 4B. Because, my lord, this is for dispatch. This is for a failure to dispatch. And please look at 12A1C. This is also, my lord, as your lordship sees, it postpones the evil day for a period after whichever is the later date in a given case. Now, my lord, 12A2, my lord, existed in the 2020 rules. My lord, Justice
That is what
yes,
I was
12A2.
referring.
Yes. Your lordship has 12A2, my lord?
Yes, yes.
May I place that, my lord, for your lordship's consideration?
Yes.
The new lessee shall ensure that the annual production beyond 2 years from the date of execution of the new lease is equal to or more than the annual production by the previous lessee, and shall subsequently work out and implement an annual production plan to ensure that the mineral resources are fully exploited during the period of the lease, failing which appropriate actions in accordance with the mine development and production agreement shall be initiated. But your lordship notices in 12A2, it is only on production. Your lordship sees
Yes,
12A2 is only on production.
Yes.
It is not on dispatch at all. And then, my lord, this proviso is inserted, as your lordships will see, on 1st of July 2021. And this makes it, my lord, completely malignant and ultra-virus. That is provided that the new lessee shall also ensure that at least 80% of such annual production is dispatched in the said year. So, my lord, this concept of dispatch is foreign and extraneous to section 4B. It is not, my lord, by implication, it cannot be read in 4B. When the legislature wanted to do it, it did it in 4A4. But when the legislature omitted,
Indicative.
That is the continuance and the additional conditions.
I'm just drawing over.
Section 3AA dispatch, 3FA, they came into force on 28 March 2021 in the Act.
True.
But my lord, production and dispatch, your lordship saw only in 4A4, not in 4B. There's no mention of production and dispatch. There's no word dispatch in
True.
4B. 13(2)AA, my lord, is the rule-making part for 4B.
True.
And this is the rule, my lord, which they have made 12A. And your lordship sees the heading, additional conditions for commencement and continuation of production as per section 4B of the Act. And sub-rule 1, my lord, was there in 2020.
Certain times marginal note may not be.
I agree. It's not conclusive. It is only, my lord, an aid to construction. Take it from me. I completely acknowledge that. But my lord, what I'm pointing out is this 12A1 was in the context of ensuring level of production. The emphasis on the rule is on the level of production. The ensuring of minimum dispatch of 80% was in the context of ability to produce so that you can dispatch if there is a demand. But 1A now, my lord, makes it a compulsive obligation and, my lord, fastens you with a penalty with reference to a money which, my lord, is a part of my bid. And let's now look at the auction rules. So your lordships will straight away see my point, because they are actually charging under 12A1A what is payable, my lord, when I sell the mineral. When I actually remove the mineral, I am supposed to pay that fee, my lord, that bid. Please come to, if your lordships would be good enough, my lord, to come to the mineral auction rules, which begins at page 487 in your lordships. Please see, my lord, this begins at page 487, and I'll take your lordship straight to Rule 2C first. At page 487, 2C is mine, development, and production agreement. Means the agreement referred to.
Just 1 minute.
Sorry, I'm so sorry.
Which one you are referring?
My lord, this is at page 487. These are called the
487.
Mineral Auction Rules 2015.
Mineral auctions.
Oh, I understood. That's. Yes.
So, my lord, these are the rules, my lord, under which the auctions were held.
Yes.
These are those rules. Now, please see, my lord, 2AA first. Auction premium. Your lordship sees that, my lord? Auction premium. Auction premium means the amount payable by the lessee under sub-rule 2 of Rule 30, 2AA. And please see 2C, mine development and production agreement means the agreement referred to in sub-rule 4 of Rule 10 or sub-rule 8 of Rule 18. And now, my lord, after this, if your lordships will straight away come to Rule 8, which is at page 491 of your lordships. Bidding parameters. The state government shall specify in the tender document the minimum percentage of the value of mineral dispatch, which shall be known as the reserve price. The value of mineral dispatch shall be an amount equal to the product of mineral dispatched in a month and sale price of the mineral, grade-wise and state-wise, as published by IBM for such month of dispatch. Now, please see three more. That's very important. The bidder shall quote, as per the bidding parameter, for the purpose of payment to the state government, a percentage of value of mineral dispatched equal to or above the reserve price, and the successful bidder shall pay to the state government an amount equal to the product of percentage so quoted and value of mineral dispatched. So, my lord, it is only when I dispatch, I become liable to pay what I have offered in my bid as a percentage. My lord, my client got an auction. He bid, my lord, at a percentage of 90.90. My lord, a high percentage. Now, he will pay that, my lord, when he removes the product, because, my lord, there has to be a sale. Only then, my lord, he's getting money to pay the government this premium apart from royalty. 90.90. That is why percentage so quoted and value of mineral so and so. And your lordships will notice that this is, my lord, rule 8. Now this, my lord, it's only upon dispatch. What does rule 12A do? If your lordships go back, my lord, to 12A, it brings in, my lord, this payment as the penalty under 1A for notional dispatch. Without dispatch, I will have to pay that money. Please see now, my lord, with me 12A, 1A, which is at page 572, my lord, in your lordship's. Does your lordship see 1A now with me, my lord? In case of shortfall in dispatch, from the minimum dispatch required under sub-rule 1, which shall be assessed on a quarterly basis, the lessee shall, in addition to the amounts payable under Rule 13 for the mineral auction rules for the actual dispatch, also pay to the state government an amount equal to the difference between the following. That is, A, the amounts payable under Rule 13 for the quantity equal to the minimum dispatch under sub-rule 1, and the amounts paid under Rule 13 for the quantity actually dispatched in the said quarter. So, my lord, what they are doing in 12A1A is the obligation which arises to pay that premium upon dispatch is fastened on me by virtue of this obligation, my lord, this compulsory obligation to dispatch 80%. This is the point I'm making. And that is why, my lord, 1C is, in cases where this lease is executed prior to this date, provisions of 1A and 1B shall apply after a period of 1 year from so and so, whichever is later. But I'm pointing out, my lord, that it is clear that the auction itself contemplated payment only after dispatch. And, my lord, therefore, how do you claim that money by attribution under 1A as if there is a deemed shortfall in dispatch? This is, my lord, the question. And this, my lord, is completely outside the universe of 4B. If it is outside the universe of 4B, my lord, then I'm afraid it is ultra-virus. This is the only test, whether it is sanctioned by the statute. And the second is, my lord, for testing ultra-virus, there are two principles. One is that it go beyond the rulemaking provision or the parent section. It goes beyond, my lord, 4B, it goes beyond 13(2)AA. That's the first submission. But the second, my lord, is, as my lord, the Supreme Court has recently held, that when you are prescribing obligations attached with a penalty, then, my lord, these are matters of legislative policy which must be found in the parent statute and not in subordinate legislation. Well, there are two principles. One is, of course, it goes outside. The second is, this is a matter, my lord, of legislative prescription. If, my lord, the legislature was conscious when it must use the word production and in dispatch, it did so in 4A4. It didn't use in 4 function by actually subordinate legislation of these rules. This is, my lord, the point as far as ultra-virus is concerned. But as I said, my lord, in my case, what they did was they issued a demand and they applied, my lord, the penal measure under 1A. That is, my lord, they calculated it on that basis and slapped me with a demand for a year, which is, my lord, violative of 1C. My lord, 1C, your lordships have seen, gives that window, at least for 1 year. My lord, my lease was executed on the 29th of June 2020. The first year finished on 28 June 2021. These rules came into force, my lord, on the 1st of July 2021. So the later date, my lord, by 1C will be 1/7/2021. But, my lord, for that period, I cannot be levied a penalty under 1A. So, my lord, dehorse, I'm saying, without, on a demurrer, without looking at ultra-virus point, I'm saying, my lord, my demand has to fall because it's completely in the teeth of 1C. So, my lord, how do they style it? They say it is a demand simpliciter under 12A1. This is, my lord, how to do it. They are falling back upon the general words in 12A1, employing the formula contained in 12A1A, which actually says it will apply only after 1st of July 2021, a later date. So, well, this is exactly the point. That is why, my lord, if this is actually read with the auction rules, it is clear it completely violates, my lord, the very fundamental basis of the auction. The auction is on the basis of percentage of the premium payable on the dispatch or the sale of the milk. Well, this is the point really about ultraviolence. In a classical sense, it is about a parent statute and authorization afforded by the parent statute and whether it is within the boundaries of the parent statute. Well, your lordships may ask me a question that after 28 March 2021, the concepts of production and dispatch were known to the legislature. I agree. But being known to the legislature, it used it in a context where it wanted to use. In 4A4, it did not use it in 4B. It did not use it in 13.2AA. If it did not use it in 13.2AA or in 4B, you cannot have it, my lord, in the scheme of 12A. So, my lord, the old rule of 12A1 must be read in its proper context to mean it is only for ensuring level of production. Because this accordance with the Mine Development and Production Agreement, which your lordship sees, prescribes, my lord, a penalty only in respect of shortfall in production. And my lord, I must tell your lordships in fairness, because your lordships asked a question, whether when we are new lessees, do we get a window for 2 years to start running? My lord, I must say candidly, because we are officers of the court, my lord, the old lease, in case of leases, my lord, where you've had erstwhile lessee, there is a mine, there is a mining plan, there is also, my lord, some sort of facility to move in quickly and generate production. So the obligation for production, my lord, minimum production, I, my lord, wish to make it clear, does not commence on the third year. It commences right from the first year, but, my lord, the prescribed parameter is average of the last 2 years of the previous list. And, my lord, in my case, I have fulfilled that criteria. I produced it, but I could not dispatch it. That's a separate story, my lord, that turns on facts. I don't want to trouble your lordships with facts. I first want to deal with the legal point. The legal point is, this is plainly, my lord, ultraviolence. Whether we look at it, my lord, through the lens of English judgments, or whether we look at it through the lens of various judgments of the Supreme Court on the subject, on both principles of being beyond the statute and on the principle that it is excessive delegation because it delegates, my lord, on a policy matter which should be prescriptive in character, which can be done only by a parent statute. So, my lord, these are the 2 points really for ultravirus. May I just hand over a compilation, my lord, of the case law and a short written note. My lord, I don't want to carry coals to Newcastle, my lord. They are all, I've given the para numbers, I've made a compilation, and my lord, they set out the position very clearly as far as ultravirus is concerned. My lord, this is a completely, it has nothing to do technically with the principle of unconstitutionality as violative of 14. This is, my lord, a principle, it is excessive delegation, and it offends the principles of delegated legislation. Please. Please give a copy to the other side. Please give a copy to sir. I mean, my lord, a short note. And in the judgments, if your lordship just looks at that index, my lord, with me for a moment, I'll just indicate, my lord, these judgments take care of all the points. My lord, I have set out all the judgments from the very beginning. My lord, these are all the classic locus classicus of Justice Mukherjee and Justice Bose. And then, my lord, Lord Diplop's judgment in the English courts. Then, my lord, followed by the Supreme Court in Singh versus Bhagat Rao and the various other decisions. Then, my lord, I must bring to your lordship's attention a recent decision of the Supreme Court, which is, my lord, serial number 18. It might be tab 18. Yes. Tab 18 in your lordship's compilation, which is, my lord, an exhaustive judgment.
Thomas Joseph.
Yeah, yes, my lord. That's right. Joseph, Thomas Joseph. Kerala State Electricity Board versus Thomas Joseph. Your Lordship is absolutely right. And there, my lord, your Lordships will notice in para 70, internal page, my lord, 60 of the report of the judgment. Para 70. Does your Lordship find, my lord, para 70? 70, my lord, in the compilation.
Yes.
At this stage, it is supposed to state that the rule-making powers of a delegating authority, if a rule goes beyond the rule-making power conferred by the statute, the same has to be declared invalid. If a rule supplants any provision for which power has not been conferred, it becomes invalid. The basic test is to determine and consider the source of power, which is relatable to the rule. Similarly, a rule must be in accord with the parent statute, as it cannot travel beyond. Now, this sums up, in my view, pithily, the position as far as ultravirus is concerned. And please see then, my lord, in para 71, if your lordships just skip, my lord, the first 8 lines, the doctrine of ultravirus envisages. My lord, I'm reading in the middle of para 71. I hope my Lord Justice Raman has that in para 70. My lord, the doctrine of ultravirus envisages that a rule-making body must function within the purview of the rule-making authority conferred on it by the Parent Act, as the body making rules or regulations has no inherent power of its own to make rules, but derives such power only from the statute. It has to necessarily function within the purview of the statute. Delegated legislation should not travel beyond the purview of the Parent Act. If it does, it is ultravirus and cannot be given any effect. Ultravirus may arise in several ways. There may be simple excess of power over what is conferred by the Parent Act. Delegated legislation may be inconsistent with the provisions of the Parent Act or statute law or the general law. There may be non-compliance with the procedural requirement as laid down in the Parent Act. It is the function of the courts to keep all authorities within the confines of the law by supplying the doctrine of ultravirus. Then, my lord, your lordships will notice in the first except, my lord, in para 72, my lord, that is useful. Before a rule can have the effect of a statutory provision, 2 conditions must be fulfilled, namely, 1, it must conform to the provisions of the statute under which it is framed, and it must also come within the scope and purview of the rule-making power of the authority framing the rule. If either of these 2 conditions is not fulfilled, the rule so framed would be void. Here, my lord, both conditions are not. Neither of them is fulfilled in our case. Because it is not consistent with 4B, it is not authorized under 32AA. And my lord, in para 73, your lordships will see 74, my lord, please see 74 in Sukhdev Singh's case. The Constitution bench is held. These statutory bodies cannot use the power to make rules and regulations to enlarge the powers beyond the scope intended by the legislature. Rules and regulations made by reason of the specific power conferred by the statute to make rules and regulations establish the pattern of conduct to be followed. And then, my lord, please see thereafter, please come to para 75. It is a well-settled principle of interpretation of statutes that the conferment of rulemaking power by an act does not enable the rulemaking authority to make a rule which travels beyond the scope of the enabling act, or which is consistent therewith, or repugnant thereto. And your lordships will then notice, my lord, there are a number of judgments, my lord, which have been quoted. I don't want to trouble your lordships by reading them, but suffice it to say, my lord, that it must be authorized by the statute. My lord, virus is always about authority. And if the statute does not authorize this rule, then, my lord, it has to fall. And this is, my lord, the central argument on ultravirus. I can cite, my lord, but I'm just saying this is, my lord, the quintessence of the point in relation to. And that is why I refer to the option rules, because your lordships could appreciate that this percentage for which I'm being penalized under 1A is, my lord, what I pay when I actually dispatch the bill. It is that upon a sale, I earn money, my lord, I pay 90.90%, apart from royalty, apart from, my lord, that the exploration trust fee, all that. In addition to it, I pay that percentage. Now, my lord, how will I pay that percentage unless there's a dispatch? And can somebody, my lord, mulct me and say, I will attribute that you ought to have dispatched a figure A. I will deduct the figure you actually dispatched and penalize you and say, you must pay. And, my lord, in my case, mine is, my lord, one of the cases of extreme irony, because I complied with production requirements, my lord. That is, I complied with 80%, that my lord, I exceeded that. I bettered in production, but I was unable to dispatch. My lord, why is it I was unable to dispatch? Your lordships must hear this case only for this purpose. It's an exemplar. In my case, my lord, I'm only for a captive use. I am not a non-captive mine like Dr. Singhvi's client. I am, my lord, a captive mine. And because it is a captive mine, my lord, my plant must have the capacity for using that material. I'm only entitled, my lord, to use it for captive purposes. Now, my lord, I applied to the state government that I have acquired a subsidiary, because they said you can even give it to a subsidiary company of yours. I said, all right, I have acquired a subsidiary. Please give me permission, amend the agreement to include that subsidiary so that I can dispatch it. My lord, they sat over the matter. I had to come to the court. I had to get a mandamus from your lordships. It is only after your lordships passed the order, after a delay of about 7 to 8 months, they finally grudgingly, my lord, amended the agreement and gave permission to give it to the subsidiary. And after the subsidiary came, my lord, there's never been any default. Never. So this is, my lord, a classic case, I'm telling your lordships, where there is, my lord, arbitrariness writ large on the face of it. And when I point out that you have slapped a demand under 1A when the rule doesn't apply to me for the first year, they say, no, we have applied it under 12A1. That is why, my lord, I'm urging your lordships to look at 12A1, either read it down or strike it. It is still one of the two. Reading it down means, my lord, it is only an emphasis on level of reproduction. And, my lord, there is one more judgment, which I may just indicate, which is, my lord, at, yes, Dr. Singhvi also referred to it, in tab 19, my lord, which is in para 37, that also, my lord, refers to this principle of delegated legislation and how,
Yes,
my lord,
he has referred in Naresh
Yes.
Chandra Agarwal.
yes,
He has
so
referred.
I will need to. But there is one para, my lord, 37.7.
I think it can be.
That's right.
Can
I
be,
think
it
it's-
can be summarized. It can be summarized in, I think, 4 grounds. One is no rule without a rule-making power in the Parent Act.
Grateful.
Secondly, if the rule-making power is there, then the authority who has been conferred the rule-making power must exercise such power. Other authorities cannot, because it will go. Third principle says that it must be in consonance with the object or the purpose sought to be achieved from the Parent Act. And fourth principle is that it should not be inconsistent or repugnant to the spirit or the soul of the Parent Act.
Absolutely.
And fifth principle is it should not offend any provisions of the constitutions.
Absolutely.
And the
right.
sixth principle is on the test of Wednesbury's principle.
Absolutely right. Wednesbury reasonableness is that is also one of the species of the doctrine of ultravirus. It's actually one of the classic principles for judicial review, which emanates from the theory of ultravirus. This idea that if you violate natural justice, it is ultravirus, it is void. is again based a lot on the principle of ultramarine.
This is what I perceive the 6 or 7 principles
That's
on
right.
which one can.
And one more, if I may respectfully submit,
Correct.
is that the rule cannot do what only a statute should do.
That's
that
another
is-
good principle.
So, my lord, this is the, if I may say so, my lord, this is the content of the virus submission.
Yes. Anything more?
No, my lord, I just have to bring some things to your lordship's notice, but I won't take much, my lord. I want to give my learned friend, my esteemed colleague, Mr. Dwivedi, sufficient time. So I, my lord, will not take more than 15, 20 minutes, I think, to take your lordship's.
So you continue or?
No, my lord, I'm entirely in your lordship's hands because I was given to understand your lordship's rise at 4:30. I'm entirely in your lordship's hands.
There is no difficulty.
May I then, my lord, may I? What about your lordships?
Huh? Is there any meeting? He is otherwise his.
I understand.
My brother's suggestion is that you are at the verge of completion. If you complete, then we can hear him tomorrow. Or you want some kind of a more energy to come for tomorrow? No difficulty.
Quite reasonably energetic. But
Not
I
him.
would say,
Not him, my lord, I need more energy. I'm coughing since morning.
so, my lord, I have you.
Tomorrow first
Yeah.
matter continues. Do it.
Start the morning.
Yes. This week, I just wanted to do it. From the next week now, I have bifurcated or dissected the different categories of the matters.
Right. That's why I suggested the phone now and
That's why I just wanted.
May I have your lordships
We have-
graciously resumed?
But one thing
Yes.
I'm just clarifying, my lord. In many of cases, we are going to file the counter. So that time I will not senior may not say.
No,
this way
mostly
this.
if the entire argument which I could
Yes,
understand
yes.
from them
Legal, my lord.
is
Purely
purely on a legal provisions.
Yes. Then, but I'm not.
And Dr. Singhvi has also brought that concept of a natural justice also because the demand was slapped without any show cause notice preceding the demand. That is what is.
Say to everyone, my lord, everyone has.
So that is also a point of is a legal point, I believe.
I have a small request, my lord. Item 51, just a minute. Item 51.
Item 48, Honorable, for that.